I'm going to go ahead and get the live stream started, and then who will be presiding?
I will be.
Okay, and then did you switch out who's doing the scoring ballot then? Oh, wait, Chris, never mind.
Yeah.
No, there's just two. You're correct. All right.
All good.
You're good to begin.
All right, thank you. All right, we have now where to begin. I will be your presiding judge for today. My name is Christopher Royce. Now, before we begin officially, plaintiff, will we be seeing a battery or negligence per se case today?
Your Honor, we'll be seeing a negligence per se case.
Perfect. Well, with that, we will now call the case of the estate of Genesis Petrillo versus Peony Estates. Before we begin, plaintiff, any pretrial matters?
Yes, Your Honor. First, may we make appearances?
Please.
My name is Savannah Patterson, along with my co-counsel Lauren Patton.
Hello, Your Honor.
And Gavin Tamer.
Good afternoon, Your Honor.
Good afternoon.
And we will be representing the estate of Genesis Petrillo today. Before we begin, would you like the defense to make appearances?
Please. Defense?
Yes. My name is Maida Arangi, and along with my co-counsels Miriam Algafir.
Good afternoon, Your Honor.
Good afternoon.
And Victor Castro.
Good afternoon, Your Honor.
Good afternoon.
The defendant, Harper Martini, in today's case.
Okay. Just to be clear, is the defendant is Peony, I believe, or is it Harper?
Harper Martini. That is our party representative.
Okay. Plaintiff, any pretrial matters?
Yes, Your Honor. First, we would like to constructively tender to the bench Midland's relevant case law, Midland's rules of evidence, the stipulations and special instructions.
Okay, thank you. I have, so just for both of your team's reference, I have the exhibits pulled up, I have the rules of evidence pulled up, and then I have like the bench book for all of the rest of the documents for stipulations, things like that. So if you're going to refer to those, just give me a second to get there, but I have them all pulled up.
Yes, Your Honor. Second, we would like to notify the court that exhibits 1 through 11 have been pre-admitted and all objections have been waived, stipulation 3 and 4.
Okay, opposing counsel, is that your interpretation of the rule as well?
Yes.
Okay, perfect. And those exhibits will be answered?
May we invoke Rule 603, the pre-sworn of all witnesses?
Yes, we will assume that all witnesses have been previously sworn.
May we also invoke Rule 615, the constructive sequestration of all witnesses?
Yes, we will invoke the rule. For the purposes of 615, does the plaintiff have a party representative?
No, Your Honor.
Okay, defense?
No, we do not have a party representative.
Okay, then every single witness will be outside the scope of this jury.
Your Honor, at this time, we'd like to ask your preferences for sharing the screen. Should we instruct our timekeepers to share the screen, or would you like us to ask every time?
So ask every time. Here's how I'm going to do exhibits. I want you to act as if the exhibits that are to the person that they have a copy in front of them. So the only time that you will share these exhibits are when they have already been entered and you're as if you're publishing it to the jury. Does that make sense?
Yes, Your Honor.
Okay. Any questions on that before we begin?
No, Your Honor.
Okay.
Next, we would like to ask your preferences for striking witness testimonies after objections. Would you like us to ask, or should we assume that they're constructively stricken?
Ask every time.
Yes, Your Honor. We would also ask your preferences for opposing counsel's cameras to be on during opening and closing or cross-examinations and direct examinations, or should we turn our cameras on only during objection battles?
No, have them on, have the crossing attorney on the whole time. That way, when there's an objection, you can just unmute. You don't have to turn on your camera and unmute. Too many steps.
Yes, Your Honor. We'd also like to clarify that Peony Estates is the defendant in today's case.
Okay, that was my understanding of that as well. Harper Martini is not the defendant in a negligence per se case. Opposing counsel, is this your interpretation of that as well?
Yeah.
Or do I need? Okay, just wanted to make sure. Okay.
Finally, I would like to turn the court's attention to case law Diabil v. Fair LLP. That for the purposes of today, for negligence per se, the timeline of the construction of the wine, the 2019 Cara wine from the 2018-2019 timeline will be considered relevant in today's case.
Okay, opposing counsel, is this your interpretation of that case law?
Yes.
Okay, and the court will note that.
At this time, the plaintiff has no further housekeeping matters, and we are ready to proceed.
All right. Defense, anything further?
There are pretrial matters, Your Honor. At this time, the defense is ready to proceed with opening statements.
Okay, perfect. Well, with that, before we begin, let me check in with my co-judge, Mr. Hill. Is everything good to begin?
Yep.
Okay, and with that, plaintiff, opening.
May it please the court. Careless, contaminated, culpable. We ask that the jury keep these three words in mind throughout today as they're at the crux of the issue at hand. On June 8th, 2019, at 9:27 a.m., Genesis Petrillo died. Why? Because Harper Martini and her staff were careless, a bottle of wine was contaminated, and Peony Estates is culpable. Now, to prove this, we have to go back a couple of years. In October 2015, Harper Martini opened the doors to Peony Estates Winery and Bed and Breakfast. She, along with her second hand, Austin Lewis, knew they were in for a lot of hard work. You see, Peony Estates borders Solive Swamp, making it a phenomenal breeding ground for pests. When organic pesticides quickly failed to work, they moved to a brand, Bug Off. It's a brand of chemical pesticides, including isofenfos organophosphate. We're in this courtroom today because we know Genesis Petrillo died due to poisoning. She died on her wedding day. You will hear today in this case that how Peony Estates used and how Peony Estates stored their pesticides. Peony Estates was not hesitant to use chemical pesticides on their crops, but for the purposes of today, we will focus on how they used the pesticides indoors. In July of 2018, they used this chemical pesticide for the very first time inside the bottling area. But in 2019, when they were going to do it again, you will hear how they made a mistake. Peony Estates brought cans of pesticide into the bottling area before covering the winemaking equipment in plastic. You will hear how they brought cans of pesticide into the bottling area before moving bottles of wine outside of the room. You will hear how they knew this was a health code violation. You will hear how they were careless. Now, it's important to note that at this time, there was a bottle of 2019 Cara wine. This bottle was to be a present for Genesis Petrillo, who happens to be Harper Martini's future daughter-in-law. This bottle of 2000 Cara wine was the same bottle that Peony Estates was told to throw out. This was the same bottle of wine that was contaminated, and this was the same bottle of wine that killed Genesis Petrillo. As the plaintiff, we understand that we have the burden of proof in today's case. We have to prove by preponderance of the evidence, by a slight tip of the scales, that Peony Estates violated safety statutes, specifically that they violated Midlands Building Safety Code 12-100. This Midlands Building Safety Code requires that Peony Estates and companies like it train their employees properly and store their pesticides properly. Now, we have to prove that these violation of these two building safety codes was the direct and proximate cause of Genesis Petrillo's death. We will prove this by calling three witnesses to the stand. First, we will call Casey Soto, the son of Harper Martini. Casey will talk about the carelessness of Peony Estates, their focus on the wedding. It will also talk about a leak in the storage barn, which forced them to store pesticides in the bottling area, violating Midlands Building Safety Code 12-100. Second, we will call Riley O'Keefe to the stand. Riley O'Keefe was an inspector, a health inspector who came to Peony Estates multiple times and issued multiple health code violations. She will talk about the contamination within the bottling area, violating Midlands Building Safety Code 12-100. Lastly, we will call Lonnie Paris to the stand. Ms. Paris is an investigative journalist who was at Peony Estates multiple times and on multiple occasions saw the 2019 bottle of Cara wine in the same room as the pesticides. She will prove that it was this same bottle of wine that was contaminated and that was given to Genesis Petrillo, ultimately leading to Genesis's death. Members of the jury, a woman is dead. Genesis Petrillo had a PhD. She had a future husband. She had a job lined up in France. Genesis Petrillo should have been here. She could have been here if Peony Estates hadn't been careless, if they hadn't been contaminated, and if they hadn't been culpable. At the end of this trial, we ask that you find Peony Estates liable for negligence. Thank you.
Thank you. Defense, opening.
Yes, Your Honor. May I proceed?
You may.
Thank you. Your Honor, opposing counsel and members of the jury, may it please the court. The best in the business. Peony Estates is a small family-owned business that has risen to the top because of its drive and dedication. The owner of Peony Estates, Harper Martini, has been a hard worker since the day she stepped foot in the winemaking business. She started small and worked her way up. You see, before Peony Estates, Harper was a cellar hand at Rosie and Pedro Winery, where she monitored the wine cellar's climate and made sure the area was always clear of pests. Her work eventually paid off. She was promoted to vineyard manager and continued to exceed all expectations. She met all bottle shipments and never compromised quality. She eventually left Rosie and Pedro to start her own winery, Peony Estates. Savoir magazine ranked Peony Estates the best winery in the Rapid River Valley region, a ranking well earned. The journey to getting there, however, was not without its obstacles. Peony Estates is located near Salt Swamp, an area that has a lot of pests. Despite this, Harper, along with her employee, Austin Lewis, took many measures to keep their winery pest-free. Clean and safe conditions were Peony Estates' top priority. In today's case, the plaintiff has the burden to prove two elements: that Peony Estates violated the building code, which dictated proper protocol, and the ed of Genesis Petrillo. But members of the jury, you will find today that they will not be able to fulfill that burden because Peony Estates was the best in the business for a reason. As a defense, we have no burden of proof, yet we will call 3 witnesses to testify to the conditions and regulations at Peony Estates. First, Blair Osborne, an event planner who has worked with Harper and Peony Estates for 4 years. She will tell you about the professional relationship with Peony Estates and its employees. She will also go into detail about the regularly conducted routines of event planning with Peony Estates and show the staff's diligence and attentiveness in ironing out every last detail to make sure their events were a success. She will tell you that Peony Estates employed high standards when it came to hygiene and safety during the 83 events she's hosted there. Next, we will call Danny Francasio, the owner of Rosie and Pedro Winery and the former boss of Harper Martini. She will tell you that Harper always exceeded her expectations, which is why she promoted Harper to vineyard manager. Danny will tell you how important Harper was to Rosie and Pedro Winery and how Harper leaving to start her own winery negatively affected Austin Lewis, the head winemaker at Peony Estates, will testify to the fact that Peony Estates always abided by the statute and took proper protocols and procedures when it came to using pesticides. She will tell you that she trained the employees through extensive presentations on proper pesticide use and storage. And when this presentation was showed to the FDA inspector Riley, they agreed that it was sufficient. Ms. Lewis will also tell you how she made sure that each and every one of her employees knew that if they handled pesticides, they had to wash their hands before handling wine production or harvesting and change into a fresh set of clothing to prevent contamination. Members of the jury, the plaintiff will try and convince you today that Peony Estates didn't adhere to the safety statutes. However, you will see that Peony Estates was the best in the business because it had the high for hygiene and safety. That's why at the end of this trial, my co-counsel Victor Castro will come before you and ask that you find Peony Estates not liable. Thank you.
Thank you. All right, give me 1 second before we begin with plaintiff's. All right, Mr. Hill, are you ready to go proceed?
Yes, I am.
All right, plaintiff, you have any witnesses to call?
Your Honor, at this time, the plaintiff calls Casey Soto to the stand.
Mr. Soto, a reminder that you have been previously sworn at this time.
Mhm.
And you may proceed.
Thank you, Your Honor. Please state your name for the court.
Hello, my name is Casey Soto.
And what is your relation to today's case?
My mother owns Peony Estates, and I'm also here because of my fiance's death. The last thing I wanted to be doing today was testifying in court.
How is your relationship with your fiancee, Genesis Petrillo?
Genesis was the love of my life. She had the capability to walk into a room and make everyone smile. And she also had the capability to beat anyone at the beer pong table. She was amazing.
And how is your relationship with your mother, Harper Martini?
Mom was always there whenever I needed her. Whether it was a soccer game or a school play, she was there. I mean, sometimes she was a little too there, like whenever I went off to college, she followed me for a little bit, but she was there for me when it counted.
What were you and Genesis doing in the summer of 2018?
That was actually the summer Genesis proposed to me. I was going to propose to her, but I guess I took too long, and she said that she was tired of waiting to propose to me. Immediately afterward, we began planning for our wedding because we didn't want to waste any more time.
And how was the wedding planning?
Hectic. Me and Genesis were doing fine on our own. And then my mother stepped in and hired a private event planner to plan our wedding without us knowing for a while. It was a surprise whenever we found out.
Where did you guys end up getting married?
Oh, we never got to get married, but if we did get married, it would have been at Peony Estates.
Was it always the plan to have your wedding at Peony Estates?
No, originally we were going to have it at Rosie and Pedro, where Genesis proposed to me, but Harper said that my mom said she really needed to have it at Peony Estates. That way they could have the good publicity and give them that title of best in the business because they really needed the good publicity.
All right. Let's talk about your knowledge of the Peony Estates winemaking operation. What knowledge would you have of the Peony Estates winemaking operation?
I actually have quite a bit. My mother volunteered me there to work over the summers. And I say volunteer because I wasn't being paid. I also gave my mother the idea to change it from a winery to a bed and breakfast because a winery, it's just been there, done that. You need something to put it over the top. And so I know a lot about Peony Estates.
Did you have any hesitations about having your wedding at Peony Estates?
Yes, it's no secret that Peony Estates is prone to having issues. One issue being the leak in the storage barn.
What leak in the storage barn?
Well, there was a leak in the storage barn where they stored all their stuff, resulting in them having to move everything inside.
And what sort of things were kept in this storage barn?
Mainly pesticide, I want to say cleaning supplies and a bunch of other stuff, but I remember there being pesticide.
And to your knowledge, did they ever move, where did they move the contents of the barn?
My mother said that the only space that they could move everything to was the bottling area. Now, I wasn't so sure about that, but mother knows best.
And to your knowledge, did they ever move everything out of the bottling area?
I can't say to my knowledge that they did. They needed to raise the money to fix the storage barn, and they were a little bit tight on money.
Were there any other issues at Peony Estates?
Yes, my mother complained about a bad health inspection they had received, something about improper pesticide storage. Yes, and she said that the inspector said they weren't storing it right. And it freaked me out. I mean, I was having a wedding there and they just received a bad review. So I told her, let's just push back the wedding until things are good.
And what was Harper's response to you asking her to push the wedding back?
She acted as if it was no big deal. She said that, no, they just have to put up signs. And so I reluctantly agreed to have the wedding at Peony Estates.
Objection to hearsay to Harper Martini's statements made out of court.
Okay. What specific statement are you objecting to?
Harper said she put up signs.
Okay. Response?
Yes, Your Honor. This would be an omission by party opponent. Therefore, it would not be hearsay.
Okay. Response on those grounds?
I withdraw my objection.
All right. Well, in that case, then objection withdrawn.
All right, moving on, Mr. Soto. I now have to ask a few questions about the death of Genesis Petrillo. If you need a break at any time or it gets to be too much, please let me know and I can stop.
Go ahead.
When was the last time you saw Genesis alive?
It was the night, well, it was supposed to be the night before our wedding. It was a rehearsal dinner. It was late and I was tired, so I decided to go to bed. I went, kissed Genesis goodnight, told her I loved her, and that would be the last time I would hear her tell me she loved me back.
When did you learn that Genesis had been taken to the hospital?
The next morning, I had gotten ready for what was supposed to be the big day, the wedding, and then Angel, one of our friends, came in wearing the same clothes, and before I could register that she was wearing the same clothes, she said something about Genesis, pesticide, and coma.
Objection, hearsay. Angel Rodriguez's statements are an out-of-court statement being made to offer the truth of the matter asserted.
Okay.
May I respond, Your Honor? Yes. These are not being used for the truth of the matter asserted, simply the effect that it had on the listener. As you will hear, when Casey Soto heard that Angel Rodriguez said Genesis and then coma, she quickly rushed to the hospital. These are not being used for the truth of the matter asserted.
Counselor, is there any contention today that Genesis was not in a coma at that time?
No, there is no contention, Your Honor.
Sorry, I put Miss Orangi. Sorry. Is there any contention on your part about Miss Genesis being in a coma at that time?
No.
Okay, with that, then the objection is overruled.
Would you like me to repeat the question?
Yes, please.
When did you hear that Genesis had been taken to the hospital?
After I'd gotten ready for our wedding day, Angel ran into the room and told me that I can't remember everything. All I remember is Genesis, pesticide, and coma.
What happened when
And
you
then I
arrived
rushed
at
off to the hospital.
Oh, excuse me.
Whenever, you never realize how important the little things are. Maybe if I had been a little bit faster, I would have been able to make it in time. Maybe if I had ran the yellow light, I would have been able to make it in time. But I was 5 minutes too late. I was 5 minutes too slow, and Genesis died alone.
Objection to narrative. The witness is clearly providing a narrative to this response.
Response?
May I respond, Your Honor? Oh, yes, sorry. Mr. Soto is simply giving his testimony as to what he saw when he went to the hospital. Not only that, but I don't believe that narrative is an objection in the state of Midlands, and therefore I asked my witness to be able to continue with his testimony.
So we do recognize the narrative. I'm going to recognize the narrative objection. However, I don't believe the witness has delved into a narrative at this point. If you think that he goes outside that scope, then feel free to re-raise. But at this time, I'm going to overrule objection.
Yes, Your Honor.
What did the doctor say was Genesis's cause of death?
Pesticide poisoning. It immediately made me think of Peony Estates.
And why is that?
Well, the night before, we had the same things. We both love chicken, and we had the chicken. We also both had the cake, champagne, and soup. The only thing we didn't have was the bottle of wine my mother gave Genesis.
Would you be able to identify this bottle of wine if shown to you in court today?
Yes.
Your Honor, at this time, I would like to show the witness Exhibit 2, which has already been pre-entered into evidence.
Okay. Any objection to publishing this to the jury, opposing counsel?
No, Your Honor.
All right, you may do so.
Okay. Awesome. Thank you. Casey, is this that bottle of wine?
Yes.
And is this a Peony Estates wine?
Yes, it was produced and bottled right inside the bottling area at Peony Estates.
Thank you. Timekeeper, you can go ahead and remove the exhibit. Casey, I just have one last question for you. How would you describe your mother, Harper Martini's business practices?
She refused to fix the storage area whenever it first became a problem. She refused to allow me to push back the wedding. So careless. My mother is careless.
Thank you, Casey. No further questions, Your Honor. I pass the witness.
All right, thank you. Cross,
Yes. May I proceed?
you may.
Okay. First, I'd like to say I'm sorry for your loss, Ms. Soto. I know it must be hard for you to be testifying in court today. Just to start, you previously stated that Harper was a very hands-on parent in raising you despite having to manage a winery.
Yes, whenever I moved off to college, she followed me. Wanted to make sure I was doing okay.
And ever since you were a child, Harper always expressed wanting to have your wedding at her own vineyard, Peony Estates. Is that correct?
Yes, she expressed that it was where she wanted it.
And prior to the wedding, Harper mentioned having a bad inspection. Is that right?
Yes,
And Harper also told you she would make the wedding go off without a hitch, even if she didn't like Genesis. Is that right?
Objection, Your Honor, to hearsay as to the statements of Harper Martini.
Okay, response on those grounds?
Your Honor, I'm not directly quoting Harper Martini. I'm simply saying that Harper expressed she would make sure the wedding would go smoothly.
Okay, response on those grounds?
Yes, opposing counsel said that Harper stated this would be out of court statements from Harper Martini.
Yeah, even if it's not the direct statement, I agree that it is still information that was relayed to Mr. Soto. So do you have any other response?
I'll rephrase my question.
Okay, the objection is sustained. And
Motion to strike, Your Honor.
It'll be stricken.
Thank you.
Mr. Soto, your mother, Harper, wanted the wedding to go off without a hitch. Is that correct?
yes, yes.
She put a lot of time and effort into planning all aspects of the wedding and even offered to fund a large portion of it. Is that right?
Yes, she took control of the wedding. Originally, me and Genesis were planning it, and we were doing just fine. But my mother decided that she had to step in.
And after Harper told you about the formalities that needed to be fixed, you saw signs installed around the property, such as telling employees to wash their hands. Is that right?
Yes,
Now, when was the last time you volunteered at Peony Estates?
a couple summers ago.
Right. And Peony Estates had some financial issues. Is that right?
Yes,
And Harper used the wedding to use the wedding to drum up publicity and business. Is that right?
yes. She said she needed good publicity to put them on top. They still just weren't at the best that they could possibly be.
However, Harper informed you later on that the issues were completely handled. Is that right?
Yes.
Objection, Your Honor, as to the statements of Harper Martini. Hearsay as to the statements of Harper Martini.
Response?
Your Honor, I'm simply stating that Harper assured Mr. Soto that the issues were handled. No direct quote from Harper Martini, just Mr. Soto's impression of the situation of the infestation at Peony Estates.
May I respond, Your Honor?
You may.
Opposing counsel directly said Harper told you that the issues have been resolved. Therefore, those would be Harper Martini's statements.
Yeah, I agree. The objection is sustained.
Motion to strike.
The words of Harper Martini are stricken.
Mr. Soto, were you reassured, thus deciding to continue having your wedding at Peony Estates?
Yes, but I still hesitant.
Yes, but you were reassured enough to still continue to have your wedding at Peony Estates. Is that right?
Yeah, it was my mother. I should have been able to trust her.
No further questions, Your Honor.
All right, thank you. Any redirect for this witness?
No, Your Honor.
All right.
I asked my witness to be able to step down.
Mr. Soto, you are excused. Thank you for your testimony today. 1 second before we, second witness. All right, plaintiff, any further witnesses?
Yes, Your Honor. At this time, we would call Riley Adkins O'Keefe to the stand.
All right, Ms. Atkins O'Keefe, a reminder that you have been previously sworn at this time. And with that, you may proceed.
Thank you, Your Honor. Ms. O'Keefe, please state your name and occupation for the court.
My name is Riley Adkins O'Keefe, and I am a certified health and safety inspector.
Where were you educated?
I received my Master's of Science at Midlands Rapid River Valley.
And how long have you been a health inspector?
Almost 7 years.
Do you have any other further training or certifications as part of your job?
Yes, as I stated earlier, I'm a certified health and safety inspector, and I also conduct investigations for the FDA as a designee.
How many inspections have you conducted throughout your career?
Geez, over 170.
And what is your connection to today's case?
Well, I investigated the respondent in this case, Peony Estates.
Let's talk about some of those inspections. When did you first go to Peony Estates?
My first inspection was on November 5th of 2015.
And what were your initial observations?
Well, initially, I noticed that Peony Estates was very close to Solve Swamp. This increased the likelihood that they would have a pest problem.
Do you know how they were dealing with these pests?
Yes, they were using chemical-based pesticides, specifically Bug Off, which is an isofenosophis-based pesticide.
Was this pesticide use and storage and all the compliant with all the best practices in your field?
No, they were storing pesticides in a facility that was much too close to production.
Why would it be hazardous to store pesticides too close to production?
Well, if you have pesticides near food preparation surfaces, then these surfaces can become contaminated. Consequently, any wine produced here will also become contaminated. It's very important to keep all pesticides away from any food preparation surfaces.
When did you return to Peony Estates?
That was on July 12th of 2018.
Was this a routine inspection?
No, I was following up on an anonymous tip. The DHES received a letter on July 10th of 2018 claiming that Peony Estates had a pest problem in their cellar and that their use of pesticides could lead to poisoning.
What did you do when you first arrived then?
Well, Harper asked me to start upstairs, but I insisted on starting in the cellar.
And when you met Harper this time, what was their physical demeanor?
Ooh, she was barely making any eye contact with me, and she seemed quite nervous.
When you got to the cellar, what did you see there?
Oh, I found various pests. I was able to determine that they had been there for approximately 4 to 8 weeks. This presented a potential health hazard, so I collected samples.
Can you explain for the court why it would be hazardous to have pests in the wine cellar?
Well, if you have pests near wine, in order to get rid of them, you must also use pesticide near wine. This is a clear risk of contamination.
So what did you do next?
Well, Harper asked me to, or she
Objection, Your
directed me
Honor.
to the storage facility.
Okay.
Hearsay
To which statement?
to Harper's statement. Your
Okay.
Honor, the opposing counsel has yet to determine whether Harper is an employee of Peony Estates. So for now, it is hearsay statement.
Okay, response on those grounds?
Your Honor, I don't believe it's being disputed that Harper has been named the owner and prime representative of Peony Estates. So I don't think that's in dispute. If you find it necessary, I can lay foundation that she's acting in her capacity as owner.
So what specific role are you referring to? Counsel, Ms. Patton?
Sorry, the state.
My bad.
The statement itself was a question which had no statement to it, just that Harper asked to follow to the storage cellar. So I would still say that there's not really a statement being asserted. But So there's like kind of those two
Sure.
responses.
Okay. And so let's take both of them. So what is your response to Harper Martini being an employee testifying in the scope of her employment?
I can lay foundation if necessary. It has been in the pretrial motions, she was named as the owner, so I didn't think that it was in any form of being disputed here. If necessary, I can lay that foundation with this witness, but she has already been laid that foundation throughout the trial.
Let's lay that foundation then, because I agree. I think it's not contested that she's an employee, but the specific rule is talking about it needs to be on a matter within the scope of that while it existed. So let's lay a little bit more foundation. So for now, the objection is sustained.
Yes, Your Honor. Ms. O'Keefe, who is Harper Martini?
She is the owner of Peony Estates.
And do your inspections take place during business hours?
Yes, I've met with Harper each time I've went.
So when you meet with her, is it in an official capacity as her being an owner?
Always.
So after visiting the cellar, what did you do next?
Well, Harper directed me to a storage facility where they were keeping the pesticides, and it was more than 50 feet away.
So if it was too close last time, does that mean that this time you were satisfied with the distance?
No, I found the location of it to be rather inconvenient. I was worried that if employees were to cut corners or become lazy, they would end up storing pesticides in the facility that was too close to production.
Did you see anything on this visit that would affirm that concern?
During my investigation, it became very clear that the process that Harper described was not always being followed.
So when employees were cutting corners, where were they putting the pesticides?
In that facility that was way too close to production.
On your third inspection, what date was that on?
That was on May 8th of 2019.
So in 2019, what did you find?
Oh, I found 4 major health code violations.
What were they?
Well, there were pesticides in the bottling area. There was a blocked drainage. The employees weren't properly trained on safe pesticide handling practices. And then I also saw a bottle of wine sitting on a shelf next to canisters of pesticide.
Let's go through some of these. Why is it a violation to have pesticide in the bottling area?
Well, if you have pesticide in the bottling area, it increases the risk of contamination because then the wine and the bottles can become contaminated.
Similarly, if my drain is clogged in the bottling area, how could that present further contamination?
Well, if the drain is clogged, then pesticides and other chemicals can't properly drain. This continues any contamination that is already occurring.
As far as the training of employees, what did you recommend to Peony Estates?
Oh, I recommended that Harper immediately retrain all of her employees in safe practices for handling pesticides. I was worried that if this training didn't occur, there would be future health code violations.
And would putting up hand washing signs in any way ease that concern?
No.
Lastly, what else did you see in the bottling area? You mentioned a bottle of wine. Can you describe that?
Yes, I saw a singular bottle of wine sitting on a shelf next to some pesticides, and the bottle was labeled Cara.
Your Honor, at this time I would like to tender to the court Exhibit 2, which has already been admitted into evidence.
May do so.
If my timekeeper could pull that up. Ms. Adkins O'Keefe, is this the bottle that you saw?
Yes, it is.
And what bottle of wine was this?
The Cara bottle of wine.
To clarify, was this bottle of wine with any other bottles?
No, the bottle was sitting by itself on the shelf with pesticides.
So what was your recommendation for this bottle?
Oh, I told Harper she should throw it away immediately.
Thank you, timekeeper. I can take that off, please. Finally, Ms. O'Keefe, if Peony Estates were to clean these 4 major health code violations, if they were to deal with these after your inspection in 2019, would that do anything to appease contamination that had been acquired before your visit?
Well, you see, the problem is that the production of wine had already occurred. So cleaning after the fact wouldn't change the contaminated wine.
I pass the witness, Your Honor.
All right, thank you. Cross, you may proceed.
Thank you, Your Honor. Ms. Atkins, I would like to begin by saying, due to the time restriction, I would like you to please answer with a yes or no response. I'm going to begin asking you about your first inspection that happened on November 5th, 2015. On this first inspection, you inspected the premises, including vineyard production facilities, storage spaces, and the bottling area, correct?
That's correct.
You found no violations of disease control or cleanliness requirements in those areas, correct?
Nope, just the problem with the pesticide in the storage facility.
All vineyard employees were following all the necessary protocols for cleanliness and disease control, correct?
During that inspection, yes.
Objection, relevance.
Okay, elaborate.
The relevance is on two parts, specifically the vineyards, which we are here to deal with inside storage. So any cleanliness in the vineyard is irrelevant to the negligence that we are here today to see. Further, events in 2015 fall beyond the scope of any relevant wine production that would have resulted in the contamination.
Okay, response on those grounds. You can take them both separate
Yes,
issues.
Your Honor. This is relevant to the case as I'm going to go through every area that Ms. Atkins has inspected so that the jury may see all aspects of Peonia Estates. It's also relevant because the vineyard will come up later during the case when it comes to pesticides, and the bar for relevance is very low in Midland. And if opposing counsel could restate the second objection.
It was the same objection. It was just two parts of the
Okay.
relevance, and you addressed both of them. So at this point, I think she's talking about Miss O'Keefe's experience with peony, and I think that's pretty relevant for today's case since that's what kind of peony is the issue. So I'm going to overrule the objection at this time. However, if you
Honor,
think,
if possible, I would like to now raise an objection on improper character evidence based upon the response to relevance.
okay, so just for clarification for the record, the 401 objection is overruled, and you may now hear the 404 objection.
During the objection or during the response to my relevance objection, opposing counsel stated that they wanted to show action and conformity therewith by showing a pattern of cleanliness in later dates, and that would be improper character evidence of Peony Estates.
Your Honor, may I respond?
Please.
Your Honor, I never stated that I was going to use this to show a pattern of cleanliness in later dates. I'm simply saying that I will go through all the areas that Ms. Atkins went and inspected through every inspection so that we can get a clear story on every inspection.
Okay, so here's what I'm going to do. I'm going to conditionally admit this at this time. However, Ms. Patton, if you believe that they then use this for conformity therewith at a later time, because obviously they're telling us they're going to use it later, feel free to re-raise the objection. I can retroactively redact this testimony.
Yes, Your Honor.
So for now, the objection is
Thank you, Your
overruled
Honor.
officially.
So to repeat my question, Ms. Atkins, all vineyard employees were following the necessary protocols for cleanliness and disease control, correct?
During that first inspection, yes.
And these protocols included conforming to hygienic practices, including cleanliness and hand washing, right?
Yeah, the only problem I found that time was with the storage facility.
Yes, Ms. Atkins, we will talk about that. Please limit your responses to a yes or no. You also found that the vineyard grounds were well organized and operated, correct?
Yes, during that inspection.
Ms. Atkins, you spoke with Austin Lewis, the head winemaker at Peony Estates, is that right?
That's correct.
And Austin answered your question in a detailed response regarding pest management and the water waste disposal, right?
Yes, and I was satisfied with his response.
And I'd like to go in a bit more detail about Peony Estates. Ms. Atkins, it is close to Salt Swamp, right?
That is correct.
And this made pest management process more complicated, correct?
Yes, there were way more pests than you would normally have in another area. So yeah.
Now, because of this, Peony Estates increased their pesticide usage, correct?
That's correct.
And this increase usage fell within the acceptable range, correct?
Your Honor, maybe it's my sound, but I can't hear opposing counsel. Is that just me?
Oh, I can hear. Okay. Ms. O'Keefe, can you hear?
Yes.
Okay. Ms. Patton, if something needs to fix, please let me know. Are we all good to go? Okay, we will continue.
Yes, Your Honor. In fact, higher pesticide use, in fact, the higher pesticide, my bad, Ms. Atkins, the winery staff is also aware that the maximum allowable level of pesticides per acre. Is that right?
Yes, they were using an above average amount, but it was still within acceptable ranges.
And the employees were aware of the maximum level, correct?
To the best of my knowledge, yes.
You did speak with Harper Martini, is that right?
That's correct.
You notified Harper Martini of a small pesticide storage issue, correct?
Yes, during my first inspection.
After this conversation, you witnessed Harper Martini move the pesticide to its designated location, correct?
Yes, she did. That is why I
After-
approved of her storage process for the pesticides.
Okay. And there was no safety concern upon your inspection of the wine production facility, is that right?
Not during my first inspection, no.
The facilities were found to be clean and sanitary with frequent cleaning documented, correct?
Yes, that's correct.
Now I want to move on to your second inspection on July 12, 2018. The FDA received an anonymous letter, correct?
Yes, it was a tip.
And you are not aware of the identity of the sender, right?
No, it was anonymous.
So you don't know if the sender had a conflict of interest when sending that letter, correct?
Objection.
Nope, it was
relevance.
anonymous.
Response to the relevance?
Your Honor, we're just trying to establish here that the sender has no identity and that this letter does not have any truth value to it.
I don't think that's what you're exactly asking. I tend to agree. I think you've already established there's an anonymous. I think we understand what anonymous means, so I'm going to sustain the objection.
Yes, Your Honor.
Yes, Your Honor. Ms. Atkins, you arrived at Peony Estates at 8:30 in the morning, correct?
Yes, I did.
And Harper Martini explained their process for dealing with wine cellar pests, correct?
That's correct.
The process included sealing the wine barrels, removing them from the...
Objection. Hearsay as to the statements of Harper Martini's explanation.
Okay, response.
Your Honor, we're using this statement to show the process that Riley Atkins O'Keefe agreed to and stated that was acceptable.
If I may respond.
Please.
In order to do so, they would have to be asserting that this process is true. They would therefore be using the statements for the truth of the matter asserted.
What's the actual statement?
Yes, Your Honor, I was going to state that the process included sealing off wine barrels, removing the wine cellar, and applying pesticides to the empty cellar. It wasn't a specific statement. It was just the process, a summary of the process.
Okay.
If I may respond again.
Last word.
A detailed explanation of the process that they used is a statement, and asserting that it is true to Riley Atkins O'Keefe is using the statement for the truth of the matter asserted. We don't know whether or not this process was actually followed.
I think that's... The objection is well taken, but I'm going to overrule it this time because I think for the process purposes, I think that's a little bit different for especially what she followed. I'm going to overrule.
Yes, Your Honor. So to restate my question, Ms. Atkins, the process included sealing the wine barrels, removing them from the cellar, applying pesticides to the empty cellar, and waiting 48 hours before returning to the barrels, correct?
Well, you see, I found the pest and she told me that that's what she planned on doing after I left.
But this was the process described to you, yes or no?
Yeah, the process she was going to complete after I left because I took samples of the wine.
And the process is consistent with the industry practices?
Yes, but yes, from what she told me, but then again, I didn't see it happen, so.
And upon inspection of the wine cellar, there was no violation of health or safety standards, correct?
Of the wine cellar? Where I found the pest?
Yes, upon inspection of the wine cellar, there was no violations, correct?
No actual violation, but a potential health hazard, so.
But there was no violations, correct?
No actual violation, just a potential health hazard that I wanted to look into.
Upon you asking, Harper Martini showed you the storage location of Peony Estates pesticides.
Yes, she did, and
Correct.
it was more than 50 feet away.
And this fit within the guidelines, correct?
I'm sorry, what did you say? I didn't hear your
And this
question.
more than 50 feet away fit within the guidelines, correct?
More than 50 feet? The FDA requires, yes, that is more than 50 feet.
Now I want to move toward your third inspection on May 8th, 2019. You arrived at Peony Estates at 2:35 p.m., correct?
That's correct.
You began at the wine cellar, is that right?
That's correct.
And the wine cellar was cleaned and organized, correct?
Well, I found the block drainage system, but yes, organized.
And it passed the inspection just as it did before, correct?
Well, you see, I found 4 major health code violations, so I actually put them on probation for 45 days. So pending a further investigation, then they would be cleared.
But it passed the inspection that date?
The inspection, well, I wrote down the health code violations and I put them on probation, so I wouldn't say they 100% passed the health code inspection, they just weren't shut down.
And the wine production area also had no health hazards, correct?
In the wine production area? Yes, that's correct.
And those 4 violations were in the bottling area, correct?
That's correct.
And despite these violations, Peony Estate was allowed to stay open on that probationary period. Is that right?
Yes, pending the further investigation.
And to clarify for the court, this means Peony Estate could remain open. Is that right?
Yes, pending the further investigation.
And it could still hold events?
Yes,
And Peony Estate
as long
has
as they
40
fixed all of the problems within the 45 days.
And Peony Estates had 40, okay. And from my knowledge, you know that Peony Estates did, and from my knowledge, Peony Estates never shut down, is that correct?
Not to my knowledge, yeah, I don't believe I included that in any of the reports, so.
And if they did not correct those violations, then they would have been shut down, is that correct?
Yes, that was the point of the 45-day probation.
Therefore, you agree that it is probable that Peony Estates did fix those violations since the wine production and bottling services remained open, correct?
Well, I have no idea. So you see that Genesis died within the 45-day time period, so the whole case got like super messed up.
Thank you, Your Honor. No further questions.
All right, thank you. Any redirect for this witness?
Briefly, Your Honor.
All right, you may proceed.
On cross, opposing counsel brought up 4 major health code violations, specifically what area they're in. What else did you find in the bottling area on that day?
I found that singular bottle of Cara wine sitting on the shelf with the pesticides, clear risk of contamination.
No further questions, Your Honor.
Thank you. All right, Ms. Atkins O'Keefe, thank you for your testimony today. You are excused. And 1 second before we begin our next witness. All right, I'm ready to proceed. Plaintiff, any further witnesses?
Yes, Your Honor. We'd like to call Lonnie Paris to the stand.
All right, Ms. Paris, a reminder that you have been previously sworn at this time. Before we, okay, perfect. With that, you may proceed.
Thank you, Your Honor. Please introduce yourself to the court.
My name is Lonnie Paris. I'm an investigative journalist by trade and environmentalist at heart.
Where did you receive your education, Ms. Paris?
I first received my education. I double majored in journalism and environmental science, and then I further went on to Boston University where I had my master's in science journalism. So imagine going from cheering on the Wildcats to a Boston Terrier.
And what did you want to do with your career?
I really wanted to expose corporate America's deep, dark secrets, especially those threatening our planet, because in my opinion, you can't trust most businesses, and that eventually led me to Peony Estates.
When did Peony Estates first catch your eye?
Peony Estates first caught my eye when I was working at Blitz News Networks, BNN for short, and that was August of 2016.
And how did it catch your eye exactly?
There was a tip concerning about how Peony Estates could be violating several health code violations.
Did you investigate any of these tips?
I looked into it, but I didn't find much. So I decided to keep my focus on a project that I've been working on. And not to brag, I got a Francis Leo Prize for.
Ms. Paris, when did Peony Estates catch your eye again?
Peony Estates caught my eye again in July 2018 when I was a freelance investigator.
And how did it happen this time?
I was just going through my notes and I saw Peony Estates and I decided that I would go to visit and get proof of malpractice.
And when did you first visit?
I first visited Peony Estates on July 13th of 2018, and that was on a Friday.
And what did you learn from this visit?
I didn't learn much, but I did hear about the guided tours.
Did you ever go on any of these guided tours?
Yes, I went on a guided tour that following Monday, which was July 16th.
And what did you learn on this guided tour?
On that guided tour, I learned about the harvesting schedules, and the harvesting schedules said that if the 2018 crops were exposed to unsafe levels of pesticide, it wouldn't show up until the 2019 production of wine. And I also stumbled into the bottling area.
Aside from the bottling, what did you see in the bottling area?
In the bottling area, I saw a bunch of just discarded canisters of pesticide.
Now, aside from the discarded cans of pesticide and aside from the harvesting schedule, what else did you see when you were on the guided tour?
While I was going through the bottling area, I was coming across the office of Harper Martini, which was the owner of Peony Estates, and I decided to go in that office. And in that office, I saw a pretty juicy internal memo.
Who was the memo written by?
The memo was written by Austin Lewis, which is the head winemaker of Peony Estates, and it was addressed to all the employees at Peony Estates.
Ms. Paris, would you recognize this exhibit if it was shown to you today?
Yes.
Your Honor, permission to tender Exhibit 12 on the screen.
Has this been entered?
No, Your Honor, for purposes of entering in evidence.
Well, again, lay the foundation first. We're not going to share the exhibit until it's been entered and published to the jury. So ask the foundational questions as if Ms. Paris has this exhibit with her as well. I have a copy here, and go through the process of entering it, and then we'll publish after.
Yes, of course, Your Honor. Ms. Paris, you have the exhibit in front of you. Do you have the exhibit in front of you?
Yes.
And is that a fair and accurate copy?
Yes.
Has it been changed or altered in any way?
No.
Your Honor, at this time, we would like to enter an Exhibit 12 into evidence.
Any objections?
No, Your Honor.
Well, with that, Exhibit 12 is entered, and you may publish to the jury and share your screen.
Thank you, Your Honor. Timekeeper, if you could share Exhibit 12. Ms. Paris, is this the memo that you saw?
Yes.
And what caught your eye about this memo?
What caught my eye is that there's word about a recent insect infestation that impacted the profits at Peony Estates. And that would honestly explain the discarded canisters of pesticides that I saw in the bottling area.
Thank you, Timekeeper. You can take Exhibit 12 down. Ms. Paris, did you return to Peony Estates again?
Yes, I did.
And when was this?
I returned to Peony Estates I just kept visiting, trying to get word of any 2019 wine production, and I got word of that on May 6th.
And did you go to Peony Estates any date after this?
Yes.
What date was that?
When I went on May 6th, I heard about word of the a surprise infestation surprise inspection, and so therefore I went 2 days later where that surprise inspection was happening.
And what did you see on May 8th?
May 8th, I saw Harper Martini and Riley Atkins O'Keefe.
Did you see anything else?
Yes, I also saw a bottle of 2019 car wine that I've been waiting months to see, and it was sitting in the bottling area.
Was it near anything else, Ms. Paris?
No.
Did you see this bottle ever again?
Yes, I did.
When did you see it?
I went back on the 30th. I did not see it on May 30th because the bottling area was under maintenance, but I did see it on June 7th, and June 7th was a wedding, the rehearsal dinner of the wedding.
And in what capacity did you see this bottle of wine?
The bottle of wine was in the same room as an almost empty canister of pesticide.
And when was the last time you saw this bottle of wine, Ms. Paris?
The last time I saw the bottle of wine when it was gifted to Genesis Petrillo by Harper Martini.
I tender the witness for questioning.
All right, thank you. Cross, you may proceed when ready.
Hello, Ms. Paris. Can you hear me all right?
Yes.
So did you get a tip from Danny in 2016?
Yes, Danny Francasio gave me a tip in August 2016.
And was this tip concerning Peony Estates, one of Danny's largest competitors?
Yes, it was. I get these tips all the time by competitors, and it was one of the cases.
So businesses love sending you tips and claims about their competitors, right?
Objection.
Yes, I'm.
May I be heard?
Please.
Businesses liking to send tips to Ms. Paris makes no fact in this case more or less likely.
Response?
Withdraw that question.
Okay, and the objection is, not going to strike a question, but the objection is sustained.
Yes, Your Honor.
And Ms. Paris, you did a web search and you found no prior instances of poisoning at Peony Estates, correct?
Yes,
Your Honor, improper character evidence. May I be heard?
Okay.
Opposing counsel is using this prior instance of not finding anything negligent for Peony Estates as action conformity therewith. That since the first time she looked something up and nothing appeared, that in 2018 and 2019 they weren't acting negligent.
Okay, response on those grounds?
Your Honor, I'm simply just asking Ms. Paris a question just to establish, the groundwork for the later facts in this case.
Your Honor, may I respond?
Okay.
Them establishing the greater, the foundation in this case is them showing action conformity therewith. Because Ms. Paris didn't find anything negligent in 2016 means she didn't find anything negligent in 2018, and that is what they're trying to prove today.
Yeah, but that's not necessarily a character trait, right? For purposes of 4-4, it needs to be a specific trait that's in conformity therewith. So I'm gonna overrule the objection at this time. However, I think there is something that potentially is coming up. So feel free to re-raise if you think it gets brought up at that time.
Yes, Your Honor.
And Ms. Paris, around 2018, you were unemployed and working as a freelance investigator, right?
Yes.
And you've had a history of working for corporations and investigating competitors?
Yes, that's usually my line of work, but also I can do freelance investigating.
On July 6, 2018, were you struggling to come up with a blog entry?
Yes, sometimes I just have like a little writer's block and I just decide to go through my notes, and obviously I stumbled upon Peony Estates notes.
And you went back to Peony Estates, not because new evidence showed up, but because you were struggling to come up with a story. So you gravitated towards Peony Estates. Is that correct?
I decided to go to Peony Estates just because why not if I had time to do it, because earlier I did not have time and I said that I would go back to it.
And did you hope that this story would revitalize your career?
Well, every news reporter just hopes that their next case is just the biggest case ever. So of course I hope for the best. Okay,
let's flash forward to 2018. There was still no evidence of any poisonings at Peony Estates, right?
Yes, but
I asked the opposing counsel state that question again. I didn't quite get it.
Yes. So flash forward to 2018. There was still no evidence of any poisonings at Peony Estates, correct?
Your Honor, at this time, I re-raise my objection to improper character evidence. At this point, they are bridging the gap between the 2016 instance of no negligent acts to the 2018-2019 no negligent acts.
2018, that's not the relevant time period for today. It's the 2019 instance. Is that correct?
Your Honor, I believe that in pretrial motions, we, according to case law, Diabill v. Farrell LLP, that any time frame with the production of car wine, in this case, the 2018-2019 timeline is still relevant.
I'm simply just, if I may respond, Your Honor.
Okay, response?
Yeah, like I said earlier, I'm simply just trying to set up the groundwork for later facts in the case. And that's the reason for these questions I'm asking Ms. Paris.
Your Honor, may I respond?
Yes. Also, what page is that case law on?
I believe it is page 5 of Midland's case law. Page
Oh.
6.
6?
6.
Sorry, what was the case again?
Diabel v. Oafson and Farrell LLP.
Farrell LLP. Okay, 5. Okay. Okay. Okay, response? No.
I'm just going to reiterate what I said, Your Honor, but I'm just simply trying to lay the groundwork for later facts. That's why when I asked about flash forwarding to 2018, was there any evidence of the poisonings? I'm just trying to lay down the groundwork for the witness's established knowledge about Peony Estates at that time period.
Your Honor, may I respond?
You may.
They're trying to establish foundation for a character trait of responsibility or cleanliness, but by bridging the gap between the 2016 instance and the most recent instance.
Final word, Mr. Castro?
For the sake of just moving on, Your Honor, I'll just retract that question.
All right. With that, we will then the objection is sustained.
Ms. Paris, did you visit Peony Estates for the first time in July 13th, 2018?
Yes.
And when you went there, you knew the brand of pesticide and you took note of it? Is that also correct?
Yes. Well, not on my first visit. My initial visit, I did not go to the bottling area, but on my second visit, I did notice the bug off pesticide.
Okay. And Your Honor, if I might ask permission to bring up a pre-admitted Exhibit 11 and an out of court.
You may do so.
Yes. And Mr. Shajan, if you don't mind pulling up Exhibit 11. And Ms. Paris, in this document right here, this is your sample that you allegedly got from Peony Estates?
Yes, I remember seeing that canister of pesticide that I got tested. It was by the wine bottle.
And Ms. Paris, just for future reference, if you don't mind just sticking to yes or no answers so we can get through this. Were you familiar with the brand of pesticide that Peony Estates used in 2018?
Yes, I saw it was bug off.
But you told the lab, however, that the sample came from your home. Is that correct?
I did say that because I didn't want anybody impeding on my investigation.
But you also didn't notify the FDA or any other relevant authority that you were doing this, right?
Yes, because I'm an investigative journalist, I'm supposed to get the inside scoop rather than telling everybody my business.
So this court today would have no way of knowing whether the sample was from your home or Peony Estates. Is that also correct?
That is correct, but I obtained it from Peony Estates.
And you had a friend at that lab send it to you, right?
Yes, because of course, as a reporter, you have inside connections. So I had a friend within the FDA that could test it.
But you didn't want these results shared with anyone else, right?
Yes, because who wants all of the hard work that they found to just give handed to somebody else that just finds it?
But you didn't release this info because you were scared someone else would scoop up this story and your hard work, right?
True.
Thank you, Your Honor. I withdraw my questioning period.
All right. Any redirect for this witness?
Briefly, Your Honor.
All right, you may proceed.
Ms. Paris, what was the chemical that the bottle of pesticide tested high for?
It tested high for isofenfos.
No further questions, Your Honor. At this point, I ask the witness be allowed to step down and the plaintiff rest its case in chief. We ask for a brief 5 to 10 minute recess, time permitting, before the defenses.
All right, let's do both parties. This 5 minutes work. I want to see if we can do a shorter one now. We can do a longer one before closing. Does 5 minutes work for both parties?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Okay, let's do that. Let's see, it's 41 right now. Let's come back at 46. And everybody, for all the competitors, when you come back, just turn your screen on so that I know that you're ready to go. Let's do, okay, 47. It's 42. So.
Your Honor, plaintiff is ready to proceed when you are.
Okay, perfect. Defense?
Yes, Your Honor, we're ready to proceed as well.
Okay, 1 second. Let me check with Mr. Hill. Mr. Hill, we good to proceed?
Yes, sir.
All right. Defense, any witnesses to call?
Yes, Your Honor, at this time, we call Blair Osborne to the stand.
All right, Ms. Osborne, a reminder that you have been previously sworn. And with that, you may proceed.
Could you please state your name for the court?
Hi, my name is Blair Osborne.
What is your occupation, Ms. Osborne?
So I work as a private event planner in Rapid River Valley. I'm also the CEO, CFO, and all other executive roles as founder and proud owner of Bliss by Blair Events.
Can you tell us about your educational background?
Sure. I received a certificate of completion from Midland State University's remote MBA preparatory course, which basically means I have a good grasp of small business ownership.
As an event planner, what experiences do you have planning events, Ms. Osborne?
Oh, lots of it. I arrange conferences, anniversaries, birthdays, corporate retreats, you name it, I've planned it. But I'm known first and foremost as an excellent wedding planner. Savior magazine even named Bliss by Blair Events the #1 most highly recommended event planning service across Rapid River Valley area for 4 different years.
Congratulations. What brings you here today, Ms. Osborne?
So I'm here voluntarily because I planned the wedding and associated matrimonial events of Casey Soto and Genesis Petrillo in 2019. I was also at Peony Estates on the night that Genesis became ill and unfortunately passed away.
Do you know Harper Martini, Ms. Osborne?
Yes, I do.
How did you come to know her?
So I first met Harper in 2015 when Peony Estates came to my rescue. As a new rookie event planner, I'll admit, I was a bit of a mess. One day I found myself with 2 events, both booked at the same place at the same time. I desperately needed another venue and I called every nearby location I could think of before luckily Harper saved the day and told us to come on over to Peony Estates.
Did you continue working with Harper Martini after this initial event?
Yes, of course.
How long have you and Ms. Martini been business partners?
Well, that event was so successful that we ended up creating a partnership between Bliss by Blair Events and Peony Estates that will last for the next 4 years. I've hosted 61 weddings, 12 birthday parties, 9 corporate luncheons, and 1 free no wake at Peony Estates. What can I say? I really enjoy being business partners with Harper.
Could you describe your experience working with Peony Estates?
Sure. Harper and her staff were always diligent and attentive, helping us solve any problems that arose before my clients or their guests would ever even know about it. Over the years, I developed a professional but notably warm rapport with nearly every employee at Peony Estates.
Can you tell us more about your experiences working with Harper Martini for Casey and Genesis's wedding?
Sure. Harper has always been so helpful and engaged. You know, we met countless of times to discuss the ideas for the wedding and decor. She seemed like she really wanted the wedding to be perfect for her son, as you can imagine.
Have you ever had a bad encounter with Harper Martini?
Not once have I ever had a bad encounter with Harper.
What was the management like at Peony Estates when you were there?
It was amazing. I have never seen anything other than the highest standards employed when it comes to hygiene and safety. I mean, the place is spotless. I can't name a single time I even witnessed anything mildly concerning with the production or storage of wine at Peony Estates across the 83 events I've hosted there.
Lack of personal knowledge, may I be heard?
Please.
I'm objecting to this witness's lack of knowledge about proper storage and cleanliness for wine production and storage.
Okay, response.
Your Honor, Blair Osborne is an event planner and works a lot with different areas that comes with planning events, including decorations, food, etc. And since she has worked for over 4 years with Peony Estates, so she does know what that proper store is supposed to look like.
If I may respond?
Yeah.
Yes. I will say that I would understand that Blair would have knowledge of how to set up events, but knowing specifics about whether or not wine production is done to standards of cleanliness would be far outside the scope of this witness. as they deal with front of the house matters, not production themselves as an event planner.
I tend to agree. I think that, and I think she may be using the term in a different matter, but that is a very specific term that's really important for this case. So unless you can lay that foundation, I'm going to ask that you, I'm going to strike that part of the testimony.
Yes, Your Honor.
Yes, Your Honor.
Sorry, for clarification of the record, sustained.
Ms. Osborne, have you had experience with wine at Peonia Estates during your time there?
Oh, sure. I've been there. I've hosted 83 events. I've been there for the pre-events. I've gone through venue walkthroughs. I know pretty much a lot about Peonia Estates. And
do you ever deal with food that comes with event planning?
Yes, we do. All our events have food.
And Ms. Osborne, do you know what proper storage of food may look like, or the proper use of it?
I mean, sure.
Objection relevance, may I be heard?
Sure.
The storage or use of food is irrelevant in today's case because we are discussing the storage and use of pesticides. Conflating the two is misleading and irrelevant.
Opposing counsel, why is this relevant?
Your Honor, this is relevant because the storage of wine is super important as well with the storage of pesticide, because both of them have to be taken into consideration. If both of them are not stored properly, then there could be cross-contamination.
Counselor, I don't think the objection was to storage of the wine. I think we all can agree that that is relevant, but I think the specific objection was to the storage of food. So how is that relevant in today's case?
The storage of food is relevant in today's case because the opposing counsel is stating that Harper Martini or Peonia Estates was negligent, and therefore the wine was contaminated. And we're trying to see if the wine or food or anything in that instance during that party could have been contaminated and caused the death of Genesis Petrillo.
Okay, I can follow that. I think the relevance threshold is pretty low, so I'm going to overrule the objection.
Yes, Your Honor.
Ms. Osborne, can you continue answering the question?
I'm sorry, could you repeat the question?
Yes. Do you have any experience with the storage of food or wine?
I don't have any experience with the storage of food or wine.
Have you seen how Peonia Estates stores their food and wine? And do you know the standards?
I mean, when I'm there, in my opinion, it's spotless, and they always have the highest standards employed when it comes to it.
Now, Ms. Osborne, with the current events that have happened, you're still working with Peonia Estates, are you?
So I've temporarily halted my work with Peonia Estates and released a public statement across all Blitz by Blair events, social media, addressing the incident, if you want to go check it out. I don't think Harper contributed to the death of Genesis in any way, but I had made the wisest public relations decision for my company,
Objection on opinion on the ultimate issue.
Okay, elaborate a little bit more.
Ms. Blair Osborne has just said that she doesn't believe that Harper Martini has contributed to the death in any way, trying to establish someone as who's regularly around and knows the cleanliness of Peonia Estates. This is someone who's giving an opinion on the ultimate issue.
Response on those grounds.
Your Honor, Ms. Osborne is not trying to give her opinion as if it's the truth. She's simply trying to explain why, and she has provided foundation for why she has come up with those conclusions and is trying to explain why she stopped business.
Counsel, correct me, Ms. Patton, correct me if I'm wrong, but isn't 704 specifically the definition of ultimate issue, saying that just because it's an opinion on the ultimate issue doesn't mean it's objectionable?
Yes, Your Honor. I was objecting to it in the context that they've tried to establish Blair Osborne as someone with intimate and expert knowledge of Peonia Estates cleanliness and storage, which is why I was specifically objecting to her giving an opinion in this matter.
Okay. I think that is usually for expert type thing. I don't think that this witness is going outside the scope of that. I think she's just giving her personal opinion, which she can do. So I'm going to overrule the objection this time.
Yes, Your Honor.
Yes, Your Honor. Ms. Osborne, could you again explain why you temporarily stopped working with Peonia Estates?
Sure. Like I said, I don't think Harper really contributed to the death of Genesis in any way, but I made the wisest public relations decision for my business. And frankly, as a businesswoman, I have to put that above all.
Thank you, Your Honor. No further questions. At this time, I pass the witness.
All right, thank you. Cross, you may proceed.
Thank you, Your Honor. To clarify, Ms. Osborne, you have no training about wine storage or production, correct?
Well, no.
But you've enjoyed a fruitful career working alongside Peony Estates.
Yes, Harper's always been very helpful.
And you were employed by Harper Martini as a wedding planner for the Casey Soto Genesis Petrillo wedding.
Mm-hmm.
At first, you were happy to say yes because it felt like planning for family, correct?
Yes.
However, it soon became apparent that Casey and Genesis's wedding would be the worst professional experience of your life.
Yeah, there was a lot of arguing and disagreements, and somebody unfortunately passed away. I would never consider it a good experience.
Exactly. At first, in fact, the engaged couple was unaware of that you were involved in the wedding planning.
Yeah,
Objection,
they
Your Honor.
weren't.
Relevant?
Okay.
May I respond?
Let's hear out first. For
Your
relevance.
Honor, whether or not the event planning was smooth or not, and whether Casey and Genesis agreed to it, is not relevant to the case for negligence per se.
Okay, response.
If I may proffer, this line of questioning is going to show potential bias to lie on Peony Estate's behalf, and bias is always relevant.
I agree. So I'm going to overrule the objection at this time.
Yes, Your Honor.
I'll repeat my question, Ms. Osborne. At first, the engaged couple was unaware that you were involved in the wedding planning.
Yeah, they weren't unaware, but I didn't think it was a big deal. I mean, I wasn't trying to make a disaster of the wedding, you know?
Well, in fact, Harper Martini offered you an extra 15% for agreeing to stay discreet.
Yeah.
And the final fee that you charged Harper Martini did include that extra money for your discretion.
Yes, it did.
So you continue to work on the wedding, but issues continue to arise as well, correct?
Yes, there was disagreements here and there.
For example, you were getting conflicting information about plans.
Yeah, there was unfortunately not the best communication for the designs and the gift registry.
And Genesis and Harper were carelessly contacting vendors, hiring and firing without your knowledge.
Oh, yes, there was hiring and firing here and there as well.
Specifically, the caterer, Sam Arnold, showed up and said that they were catering the wedding without you ever contacting them or being aware of that.
That's true.
So despite being the wedding planner, things were happening around Peony Estates without your knowledge.
Well, just that one thing, sure, yeah.
Well, you felt completely out of control, yes?
Yeah, it was a little messy because of disagreements on such an important event.
Clarify, you felt completely out of control.
Yeah, I should have been a little more control with all the designs and all that.
And you can't even remember everything that went wrong.
Well, no, I'm not a genius, I guess.
And then just 2 or 3 weeks before the wedding, you met with Harper and Casey.
Yes, I did.
And during this meeting, Harper got a call.
Yes, she did.
And she seemed visibly angry.
Yes.
And on this phone call, she said, "I don't care what that clown Adkins O'Keefe said. Do not waste the employee's time with more training." Did she say those words?
Yeah, I'm not too sure what the context it was in, but I agree, the employees are well trained.
But those
Your
are all
Honor. More prejudicial than probative.
Okay, elaborate.
Your Honor, there is no foundation or context in how the statement was said or why it was said, and Ms. Osborne does not know the foundation. So right now, it's just being more prejudicial towards Harper Martini than it is probative.
Okay, response
If
on
I
those
may
grounds.
respond, there is extremely high probative value that Harper Martini did not properly train her employees, as that is the matter at hand today. Also, there is no context needed for "do not waste the employee's time with more training." There's no context that can add to that. That is a full statement that directly expresses Harper's intentions.
Final word on this.
Your Honor, this still does not provide context of why Harper said this or to what statement she was specifically talking about. And Ms. Osborne does not know in what context this was put in. There's no foundation.
That's something that you can bring up with your witness. I think it's pretty clear what it's about with our prior testimony, but additionally, I don't think that there's a strongly outweighing here prejudicial effect. So I'm going to overrule the objection.
Yes, Your Honor.
Yes, Your Honor. I'll repeat what I said, Miss Osborne. Harper said the words, "I don't care what that clown's Adkin O'Keefe said. Do not waste the employee's time with more training."
Yeah, like I said, I'm not too sure what the context was in, but I agree the employees were well trained.
And she said then, "No, keep the Cara bottle where it is. No, don't have them move the pesticide." Correct?
Yes, like I said, I don't really know the context of it all.
Pass the witness, Your Honor.
All right. Any redirect?
Yes, Your Honor.
Okay, you may proceed.
Miss Osborne, what was the reason for the complications that came with the wedding planning for Genesis and Casey?
Well, Genesis and Harper argued a lot about the designs and what they wanted to do with the wedding as with the decor and all.
So those disagreements dealt with miscommunication and tension between Harper and Genesis?
Mm-hmm.
Miss Osborne, at the end, you gave Harper Martini a discount. Is that correct?
Yes, I did, as our sympathies,
Objection
because
beyond the scope of my cross.
Okay, response?
Your Honor, opposing counsel brought up money and the fact that Ms. Osborne was paid a 15% extra. And so I'm also clarifying that there was a 10% discount to that 15% extra. So in reality, Ms. Osborne did not receive that full amount.
If I may respond.
Please.
My scope, or the reason of that questioning, the scope was to show bias, that she charged 15% for her discretion. The discount of 10% because of the death of Genesis Petrillo does not go to show anything to in any way relieve that bias.
Opposing counsel, is that true that the discount only happened after the death of the individual?
Yes, Your Honor.
All right, then I'm going to agree and I'm going to sustain the objection.
Yes, Your Honor.
Yes, Your Honor. Ms. Osborne, why do you work with Harper Martini and Peony Estates?
Because Harper's such a helpful person. I mean, out of all the events I've hosted there was never a problem. Never such a tragedy like this has ever occurred over all the events I've ever hosted there.
Thank you, Your Honor. No further questions.
All right, thank you. Ms. Osborne, you are excused. Thank you for your testimony today. And give
Your
us
Honor,
1 second.
My
Sorry.
co-counsel is having connectivity issues. Would you mind just giving us a second to figure those out?
Absolutely.
Your Honor, we're just going to switch computers.
That's all good with me.
Sorry about that, Your Honor. Can you hear me?
I can.
Awesome. All right. I'm ready now. Thank you.
All right. Defense? Or, sorry. Yes, defense. Call your second witness.
Yes, Your Honor, at this time, defense would like to call Danny Francasio to the stand.
Ms. Francasio, a reminder that you have been previously sworn at this time. And with that, you may proceed.
Yes, Ms. Francasio, can you introduce yourself, please?
My name is Danny Francasio, and I'm in charge of the top winery in all of Rapid River Valley.
And would you consider yourself an expert in the wine business?
Well, of course.
Now, Ms. Francasio, let's talk about Ms. Martini. How did you first meet Harper?
I hired Harper as a cellar hand.
And what were Ms. Martini's responsibility as a cellar hand at Rosie and Pedro's?
So whenever we had pests, Harper would notify me, and we would carefully cork all the barrels and then begin spraying with pesticide.
And Ms. Francasio, would you say that pests were a common issue in a winery?
Yes, where there's wine, there's pests, but Rosie and Pedro took it very seriously.
And how often did this happen during the time that Harper Martini worked for you?
So we sprayed our winery about 4 or 5 times a year.
And how would you describe Martini's performance as a cellar hand?
I'll admit at first I wasn't so sure about Harper, but she
Objection,
really
Your Honor. Improper character evidence. May I be heard?
You may.
Your Honor, opposing counsel is trying to use this testimony that Harper Martini was a good cellar hand while she worked at Rosie and Pedro's winery to show action and conformity therewith, that she would follow those same practices in 2018 through 2019 during the Cara wine production. These instances that they're speaking of right now took place in 2012 and therefore be used for character evidence.
Response?
Your Honor, I'm simply asking Ms. Francasio to describe her previous cellar hand's work. I'm not asking her to characterize Harper's personality in any way, simply her work at Rosie and Pedro's.
May I respond, Your Honor?
Final word, sure.
The trait that they're trying to bring out here is responsibility, that Harper Martini was responsible while she worked at Rosie and Pedro's winery, that she followed all the correct steps. And then they're going to, again, talk about how in the future, that Harper Martini would have these same traits.
So I don't think it's, I can't see that it's getting there yet. So I'm going to do a limiting instruction to the jury to only take this for the purposes of Martini's time while she was working at Rosie and Pedro's, not to use this for any conformity therewith, because I don't believe we've gone into that at this point. So technically the objection is overruled.
Yes, Your Honor.
And Ms. Francasio, as a cellar hand during Martini's time at Rosie and Pedro's, did she ever display volatile management with the establishment?
No, she never did.
And is Harper Martini still employed at Rosie and Pedro's?
No, she betrayed me and started her own winery. She even took half my senior staff along with her.
Now, Ms. Francasio, let's talk more about Peony Estates. How did Harper's opening of Peony Estates affect Rosie and Pedro's?
I'll admit, Harper opening Peony Estates greatly hindered my business. She took half my staff, and our sales were down. Everything was down because of her opening of Peony Estates.
And did you maintain any form of communication with Ms. Martini after she left your establishment?
Yes, she sent a few emails and left a few voicemails.
Your Honor, may I publish a exhibit to the screens with screen sharing?
Has this exhibit already been entered?
No. I would like to enter evidence.
Then no, again, go through the foundational questions right now and then ask to enter the exhibit. We will go through that process and you can only share it whenever it has been entered.
Okay. Ms. Francasio, you said that Ms. Martini contacted you through email, is that correct?
Yes, she did.
And would you recognize a copy of that email if I showed it to you?
Yes, I believe I would.
Your Honor, may we publish the exhibit to the jury for authentication?
Again, so she should have this exhibit in front of her. You lay the foundational questions now, then offer it. I will have it here in front of me as well. And then once it has been entered, then you can show it. Because at this point, as I've already stated, when you show to the jury, when you share your screen, it's as if you're publishing it to the jury. Does that make sense?
Yes, we would like to present the exhibit constructively out of the view of the jury. I apologize.
You're not understanding my instruction. So again, ask the foundational questions right now without sharing your screen. And it's not until you enter the exhibit that I will allow sharing. So no, you cannot share your screen.
Okay. Ms. Francasio, did you respond to this email?
No, I didn't respond to that email.
And if I were to show it to you, would you recognize this email?
I believe I would, yes.
Do you have the email in front of you right now?
Yes, I do.
And has it been changed or altered in any way?
Not that I can, not my version, no.
Defense offers Exhibit 13 into evidence. Maybe sure.
Let's go through objections first. Mr. Tamer, do we have any objections to Exhibit 13?
Yes, Your Honor. I'd like to object to hearsay as to the statements of Harper Martini.
Okay. Response?
Your Honor, my witness has not attested to any direct statements of Harper Martini. We would like to publish an exhibit to show that.
Yes, but by entering this exhibit, you are entering those statements that opposing counsel was saying hearsay. So what's your response to those statements not being hearsay?
Your Honor, this is with the statements of Harper Martini in the email would be part of an exhibit, not the witness testifying to any out-of-court statement, and it would be used to prove subsequent actions.
Okay, so take those separately. So subsequent action, Mr. Tamer, what's your response on those grounds?
Which exhibit are they trying to enter again?
Exhibit 13? Is that correct?
Yes.
All right,
Yeah,
let me go
exhibit
ahead.
13.
Give me 1 second to refer to co-counsel, Your Honor.
All good.
Your Honor, my response to subsequent actions, Danny Francazio never went to Peony Estates, and he previously testified that he never actually responded to this email, so he would not be able to attest to the subsequent actions that this email had. Therefore, it would still be hearsay.
Is that correct that Ms. Francazio actually didn't have any subsequent action in this scenario?
No, we are simply trying to establish Harper Martini's business actions and management of Peony Estates after having left Rosie and Pedro's.
That's not my question. My question though is subsequent action, which you're trying to use, because is that true that Ms. Francazio did not have any interaction with Martini after making these statements?
Yes.
Then I'm going to have to agree with Mr. Tamer that this is hearsay. So unless you have any other exceptions, then I'm going to sustain the objection. Anything further?
No.
All right, then the objection is sustained. Exhibit 13 is excluded.
Ms. Francazio, did you ever provide Ms. Martini any tips for managing pesticides after she left Rosie and Pedro's?
Yes, I did. I just wanted to make sure she was providing the same standard that she did at Rosie and Pedro at her winery.
And did Ms. Martini have to take a course to get a liquor license?
Yes, everyone that operates any alcohol-related business.
Objection, Your Honor, relevance. I don't see why her having to get a liquor license makes any fact in this case more or less likely.
Response?
Your Honor, I'm about to lay that foundation in my very next question if I'm allowed the opportunity.
Can you proffer what it's going to be?
Yes, I'm going to be referencing to the pesticide training that is involved in getting that liquor license.
Oh, okay. For that purposes, then I'm going to overrule the objection.
Yes, Your Honor.
You may proceed.
Proper pesticide usage part of that course?
Yes, it was. I even trained Harper myself.
And would Peony Estates' shutdown affect you or Rosie and Pedro's in any other way?
Yes, I will admit Peony Estates shutting down would greatly affect us. But I love competition, and I welcome any sort of competition, especially from Peony Estates.
And just to reiterate, after Harper Martini left Rosie and Pedro's, you still maintained communication with her when she reached out to you for help, is that right?
Yes, I did, just to ensure she was doing a great job.
And based on what you know, have you formed any conclusions on this case?
Yes, it is my conclusion that Harper Martini knew what she was doing when she worked at Peony Estates. So I find it hard to believe that she would be negligent in her own business when—
Objection, Your Honor, to character evidence. The witness is currently stating that because of her training that she gave Harper Martini while she worked at Rosie and Pedro's, therefore she would be well trained at Peony Estates. The character trait I'm trying to show is they're trying to show is responsibility. Therefore, it'd be character evidence.
Response?
Your Honor, the witness is providing their rationally based perception of Harper Martini in their own opinion.
Okay, but what's your response to 404? That she can do so, but she's doing so based on propensity, based on something that she did in the past and using propensity therewith, conformity therewith.
This is based on what Ms. Francazio has known since Harper worked at Rosie and Pedro's and after having left Rosie and Pedro's, since they have maintained communication past that point.
Because the opinion is based on what the actions that they did in the past, and she's basing her opinion on that, I'm going to have to agree with the opposing counsel, and so I'm going to sustain the objection.
Motion to strike Danny Francazio's testimony about Harper Martini's work.
It'll be stricken.
Yes, Your Honor.
Thank you, Your Honor. I pass the witness.
All right, thank you. Cross?
Yes, Your Honor. Ms. Francazio, Harper Martini worked with you as an employee at Rosie and Pedro's, correct?
Yes, she did.
And throughout her time there, she had many responsibilities, correct?
Yes,
Including taking care of pesticides.
that's correct.
However, in 2015, Harper Martini betrayed you, correct?
Yes, that's correct. when she left.
And yes, and she opened a new winery called Peony Estates, correct?
Yes, that's correct.
And you told Harper Martini that you would never step foot on Peony Estates, correct?
And I never set foot in Peony Estates, correct?
Yes, you never went to Peony Estates, right?
Correct.
And you also told Harper that you never wanted to speak with her again.
Yes, but I still maintained communications with her through email.
Yes, you continued to whenever Harper reached out to you, you did respond to her, right?
Yes, on occasion I did.
On multiple occasions, Harper reached out to you asking for help when it came to handling pesticides, right?
Yes, she did.
And you responded to her, right?
Yes, on several occasions I did respond.
However, you never stepped foot on Peony Estates, did you?
Objection, Your Honor. Counsel is referring to facts not entered into evidence.
Can you elaborate on that?
He is referring to a past communication with them through email about Harper asking for help with pesticides that has not been entered into evidence.
May I respond, Your Honor? Yes. It's stated in her affidavit that Harper Martini reached out and asked for help when it came to storing pesticides, and it also states in her affidavit that she did indeed help. It's on, let me see here, line 79 in her affidavit.
But that's not what the objection. I mean, the objection is to facts not evidence about an email exhibit. And just because it's in her affidavit does not also mean that it's in evidence as well. So what's your direct response to what she's objecting to?
I'm not going into the contents of the email, simply that Harper reached out with the email and Danny Francazio responded.
I tend to agree. I think that if you start delving into the contents, then you can re-raise your objection, but I don't think that's the case that we have here. So the objection is overruled.
Yes, Your Honor. Moving on, Ms. Francazio, you never stepped foot on Peony Estates, correct?
That's correct.
So you would not be able to testify to anything that Peony Estates did regarding the storage or usage of pesticides, right?
That may be correct, but Harper did reach out to me about the proper pesticide storage.
Yes, she reached out to you with concerns. However, you never went to Peony Estates to see if she had actually implemented your advice, did you?
Yes, that's correct.
And lastly, just to reiterate, excuse me, 1 second, Your Honor. No further questions, Your Honor. I pass the witness.
All right. Any redirect for this witness?
Yes, briefly, Your Honor.
You may proceed.
Mr. Ocasio, would you benefit from Peony Estates shutting down?
Yes, I would benefit greatly.
However, it is still your statement today that
Objection, Your Honor. Outside the scope of my cross-examination, I never brought up her bias.
Thoughts?
She already answered the question. I can just strike it from the record.
All right. We'll strike that from the record then. So objection sustained.
Yes, Your Honor.
And Mr. Ocasio, after Harper left and you still maintained communication with her, you still believe that she had not broken any statute. Is that correct?
Yes, that's
Objection,
correct.
Your Honor. Leading.
No. No.
I'm going to sustain that objection.
Motion to strike the partial response.
Stricken.
No further questions, Your Honor.
All right. Ms. Francazio, you are excused. Thank you for your testimony today. And 1 second before we do our third witness for the defense. All right. Defense, any further witnesses?
Your Honor, at this time, the defense calls Austin Lewis to the stand.
Ms. Lewis, a reminder that you have been previously sworn at this time, and you may proceed when ready.
Hello, would you please introduce yourself?
My name is Austin Lewis, and I'm the head winemaker here at Peony Estates.
How did you get established in the wine business?
Well, after moving from the UK to the US, my mom took lead in the production of the wine at the Old Cumberland's Farm Winery. When Danny bought the place, she fired my mom, and I think she realized later down the line that it was a mistake. However, it was a little bit too late at this point since my mom had passed away. That's when she came to me, and that's how I ended up working at Rosie and Pedro.
And who did you meet while working at Rosie and Pedro?
I had made several friends while working there, but none of them compared to Hopper Martini. Working with wine pairs well with making new friends, if you know what I mean. I've always made meaningful relationships in the break room over a glass of wine. That's actually how Martini and I became friends, you know.
What made your friendship with Harper so special?
Well, we had similar values about family and wanting to start a business that was founded on these ideals. Hopper was always driven, knowledgeable, kind, and
Objection,
I know.
Your Honor. Improper character evidence to Harper Martini's personality traits of proper and kind.
Okay, response?
Your Honor, my client is just simply answering the question based off her present sense impression of Harper at the time.
Yeah, Ms. Patterson, how exactly is kind going to be a conformity there with a negligence per se case?
Your Honor, focusing more on the proper personality trait that since Harper Martini was always this way, that she always acted in her capacity as owner of Peony Estates in one way that she wouldn't.
I think you're taking that out of context with what the witness was trying to say. I'm going to overrule the objection.
Yes, Your Honor.
How did you end up? Oh,
sorry.
sorry about that. You may finish your question, Ms. Lewis.
Like I was saying before, Harper can be a lot. And I'll be honest, I thought she was a bit loony when I first met her. However, you know, after a couple days and steering clear from her, I decided that it was worth giving her a shot when I heard that she was going to start her own business. So ever since that day, me and Harper have been very good friends.
So how did you end up working at Peony Estates?
Well, Harper offered me a position as head winemaker at Peony Estates around January of 2015. This position also came with a substantial raise and a 10% stake in the company.
Or let me rephrase this. Was there any problems at the beginning of the business at Peony Estates?
Why, of course, the land that she had bought was a little bit close to the swamp, which made it very susceptible to having an increase in pest problems.
And how did you handle the pest problem at Peony Estates?
Well, at first we tried to use organic solutions, but they became very expensive and they were not showing any results. So we decided to switch to a chemical pesticide called Bug Off.
And did you instruct the employees on proper safety techniques?
Yes, we required all of our employees to change into fresh clothes and thoroughly wash their hands after handling the pesticides. There was also designated areas where those chemicals were to be kept in a shed on the other side of the grounds.
Now, are you familiar with the danger of, chemical pesticides and possible cross-contamination?
Yes, but switching to the chemical pesticide was our last option. We wanted to do whatever it took to make sure it was still a safe measure to use.
So what did you do to prevent cross-contamination in light of this danger?
Well, if we're being honest here, I never exactly liked the idea of using it on the crops, but Harper said it was our last choice at this point. And she did say we could throw out the grapes that were in the particularly waterlogged areas, and that did make me feel a little bit better.
So where did you end up spraying the pesticides?
At first, it was only at the foundation of the buildings, but after a pretty bad infestation in the wine cave and the bottling area, we took to spraying to the vines.
And how did you ensure that these vines were sprayed safely, considering that it is pesticide that's being sprayed on them?
Objection or relevant, may I be heard?
Sure.
Whether or not Peony Estates spread pesticides on the crops themselves make no fact in this case more or less likely, as we are focusing on specifically the storage of the pesticides and the proper training of the employees.
Response on those grounds?
Your Honor, this is most definitely relevant because if there's an established way that they do pesticide spraying, which in this case it's in the crops, then it relates to how they store the pesticide, right? It's just this is how they spray it, and then how they store it is a result of the care and concern that they take when spraying it. So it is relevant because it shows the business caring and following these safety measures.
Yeah, it's gonna be hard for me to sustain a relevance objection talking about the business practice of P&E. I understand that the theory today is related to the storage only, but in the defense, it's their job to make sure that their practices were in confining with that statute that I believe goes into with that as well. So I'm gonna overrule the objection.
Of course, Your Honor, at this point, I would like to raise an objection to improper character evidence. Like my opposing counsel said, they're using this to show action conformity therewith, that if they were using best practices in their plants, that they would be using best practices in their storage of the wine.
Your Honor,
no need. That's not how 404 works. So overruled.
Okay. If you may, Your Honor, I'm going to re-ask the question again. Ms. Lewis, how did you ensure that the vines were sprayed with the pesticides safely?
Well, it was more of a reactive approach, if you ask me. I inspected the crops and made sure the decisions of which vines were usable and which were not. A small observation to note is that I had to end up throwing away about 20% of our grapes every year from the areas that had the worst drainage.
And did you ensure that this was done annually?
Why, of course, I did it every year. However, in 2018, I did have to leave for a personal matter. So I instructed Harper to not harvest the grapes that I had roped off. Harper agreed without complaint, and so I have full faith our vines were safe.
And you did train the employees on the safety measure, right? The proper protocols for handling pesticides?
Yes, we made the switch, and I made sure that annual training was mandatory.
And what did that training include exactly?
There was an extensive presentation on proper pesticide use and storage. We showed it to the FDA Inspector Riley, and they agreed that it was sufficient. I also made sure that each and every employee knew if they handled pesticides, they were needing to change an outfit. So this practice all started in October of 2015, and we've been using them ever since.
And Ms. Lewis, just to clarify today, you didn't just put up signs that said wash your hands, right? You did more than just, putting up little signs saying to wash your hands.
Objection, Your Honor, leading.
Sustained.
Has there been any instances where customers consumed contaminated wine prior to 2019?
No, we have always had a clean bill of health ever since opening.
And is 2018 any different in the previous years following this protocol?
Nope, we did the exact same safety procedures and training that we had done for years.
And did you have any health inspections in 2018 before the wedding?
Yes.
And what came of this inspection?
Well, we were cited for storage of our pesticides in a nearby shed because they were about to empty the wine caves for spraying pesticides, but it never went into the cave while the wine was in there. We emptied the wine cave of all wine and sprayed the building and didn't return the wine until 48 hours later. This is what we use as standard procedure.
And when this citation occurred, did the inspector test the wine?
Yes, it was during that 2018 inspection that they took samples from 20 of our wines, and they were all completely clean, and I'm not surprised by that.
And were you forced to shut down Peony Estates after that?
Nope, not at all.
Okay, and we'll just move forward. Was there any inspections leading up to the wedding?
Yes, on May 8th, 2019.
What were the results of this inspection?
Well, that day we had a pretty bad mite infestation in the bottling area. So we moved the pesticides into the bottling area, completely sealed, and we didn't use them. And just as we were about to move the bottles out, the inspector came in. I mean, that's just our luck, right?
And what happened when the inspector came in?
Well, even though we never actually used the pesticides in the area when the bottles were there, we got cited for it. That posh inspector had also mentioned something about a blocked drain.
And were you forced to shut down Peony Estates as a result of that incident?
Oh, heaven no. We were just on a probationary period for 45 days after that. And the inspector never told us that the citation was so serious that we had to shut down.
And are you aware that the police found pesticide in the bottle of Caro wine found in the trash?
Yes, but that's only because we threw away so many canisters of pesticides.
Sorry, can you restate that? I didn't hear that.
Leading question.
What was the way the question was formed?
Yeah, if Your Honor, if you'd like me to repeat the question, it was, are you aware that the police found pesticide in the bottle of wine found in the trash, the Cara wine?
I'm going to sustain the objection, rephrase that question.
Motion to strike partial testimony.
I'm not going to strike the question.
Yeah. So was pesticide found in the Cara wine in the trash?
Yes, but that's only because we threw away so many canisters of pesticides, and they aren't always empty when we throw them away. Sometimes they do leak out because, they're in a dumpster. Trust me when I say that we treat that trash area like nuclear waste.
Thank you, Ms. Lewis. Thank you, Your Honor. I pass the witness.
All right, thank you. Cross, you may proceed.
Thank you, Your Honor. Ms. Lewis, you started working at Rosie and Pedro's in 2012, right?
That is correct.
And you switched to Peony Estates in 2015.
Yes.
This is because Harper Martini offered you a raise.
Yes.
As well as a 10% stake in the business.
Yes, like I said before in my testimony already, she offered me a substantial raise and a 10% stake in the company.
So you have invested interest in the success of this company.
Why, of course. Why wouldn't I be interested in a company that I take part in?
You've invested financial interest in the stake of this company?
That is correct.
And it is likely that if Peony Estates loses this case today, that you would lose your job.
I mean, yes, because I would be out of a business, but
that's just speculation. That's a speculation, and if you allow me to elaborate on that,
Sure.
There's no way that my witness would have any knowledge concerning that Peony Estates would shut down as a result of the results of this trial. So it's just pure speculation. That question is.
Response?
Yes, Your Honor. As Ms. Lewis has stated, she has a 10% stake in the business. She is a investor in the business. She would understand the financial burdens of taking on this investment. Therefore, she would be able to testify whether or not that losing this case means that they're in a worse financial place, and therefore Peony Estates would have to shut down.
I tend to agree. I think also this is cross-examination. If she does not know the answer, she can feel free to say so. So this objection is overruled.
So Ms. Lewis, you would agree with me that it is likely that if you lose this case, Peony Estates will shut down and you'll be out of a job.
I mean, yes, but I just want what's best for the company,
Ms. Lewis, that wasn't my question. That's it. My question was, it's likely that you would lose your job, right?
That is correct. Just because, this does cause some bad publicity for the company.
Of course. Moving on to 2015. So Peony Estates borders Olive Swamp, right?
Yes.
It's a phenomenal breeding ground for pests.
I wouldn't say, extraordinary or whatever, but we do tend to have quite a pest problem.
So you started using organic pesticides on the plants?
That is correct.
But it didn't work?
Yes.
So
they did not show it.
Right. So you switched to bug off?
Yes.
Because it was cheaper than organic pesticides?
That, along with the fact that, the organic stuff just didn't show the results that, we needed. And in order to make sure there was a safe product for all clients, we needed to make sure that all those pests were gone.
Of course, Ms. Lewis. And you didn't use chemical pesticides until 2018 inside the buildings?
That is correct.
In July of 2018, you sprayed chemical pesticide inside the building for the first time?
Yes, because we did find an infection in there.
And in 2019, in May, you were going to do it again, right?
Yes, that is correct.
But you made a mistake this time, isn't that right?
What mistake are you referring to?
You put the cans of pesticides into the bottling area before wrapping the equipment in plastic?
Yes, but they were tightly sealed and everything.
But that's a yes to my question. You put the canisters of pesticide in the bottling area?
Yes.
And you put the canisters of pesticide in the bottling area before moving out the rest of the bottles of wine, isn't that right?
That is correct.
And you knew this was a health code violation, didn't you?
I did know it was a health code violation, but like I said, we did not open those pesticides before.
Ms. Lewis, that's a yes to my question that you knew it was a health code violation.
I did say yes already.
And Ms. Riley Adkins O'Keefe actually cited you for this health code violation.
That is correct.
And this citation happened a month prior to Genesis Petria's death.
Yes, that was the third inspection, I believe.
And you were also put on probation a month prior to Genesis Petria's death.
Yes, they said that they were going to check in within 45 days, but, they never told us that we had to shut down.
But you were put on probation?
Yes.
And at this point, you told Harper Martini that that the business needed to be more careful with their use of pesticides. Isn't that right?
That is correct.
And you told Harper that you needed to retrain your employees.
That is correct.
But Harper forbade you from retraining your employees, didn't they?
I mean, Harper just didn't see the point in it. So yeah.
She actually forbade you from retraining your employees. Yes or no, Miss Lewis?
Your Honor,
That is correct.
objection.
Elaborate.
That's hearsay. What the plaintiff is doing is they're offering an out-of-court statement that Harper supposedly said to elicit a response from my witness.
Your Honor, may I respond?
Please.
This is not hearsay, as this is an admission by party opponent.
Great response on those grounds.
Just withdraw.
Okay. The objection is overruled.
Miss Lewis, that is a yes that Harper forbade you from retraining your employees.
That is correct.
And that it would take away from their jobs?
Yes.
And it would distract from the wedding, right?
That is correct. We had a lot of preparations to do.
Harper even said everything has pesticide on it nowadays and no one ever dies from it. Isn't that true?
I mean, she is correct. Hardly anyone ever die.
Miss Lewis, my question was, did Harper say this?
That is correct.
And is it your understanding that everything has pesticide on it as well?
I cannot speak to that matter.
So you did not just say in your testimony that everything on it, that you agree that Harper is right, that everything on it nowadays has pesticide on it.
I mean, she was right in that manner, so yes.
Harper even told you about a previous time that one of your own employees drank your wine that was contaminated with pesticide, correct?
That is correct.
And this employee almost died, didn't she?
Yes, from my knowledge.
This was a Peony Estates wine that was contaminated?
Yes.
And it was contaminated because this glass of wine was left out during a routine spray of pesticide, right?
Can you repeat that? I couldn't hear, sorry.
This glass of wine was left out?
That is correct.
And then it was contaminated with pesticide during a routine spraying of the bottling area?
Yes.
So that glass of wine was not covered?
Not from what I know.
And that employee almost died?
You know, accidents happen and
Miss Lewis, that was not my question. This employee almost died because she drank pesticide, correct?
That is correct.
I pass the witness, Your Honor.
All right. Any redirect for this witness?
No, Your Honor. I just asked that my witness be allowed to step down.
All right. Ms. Lewis, thank you for your testimony today. You are excused. Defense, do we have anything further?
No, Your Honor.
Okay. So with that, does anyone know what time all loss is? Or around where it is?
All losses at 5:05, I believe.
5:05. Are we good with then just doing a 5-minute break for both parties?
Yes, Your Honor.
Was that, sorry, I can't see. Was that plaintiff defense?
Oh, yes, that was plaintiff. My bad. Yes, Your Honor.
Okay. Defense, are we okay with just 5 minutes?
Yes, Your Honor.
All right. So then we will be back at 46. All right, I see closing for the plaintiff. Defense is closing ready.
Yes, Your Honor.
Perfect. And then before we begin, Mr. Hill, are we all good?
Yep, I'm ready.
Okay. Mr. Tamer, you may proceed when ready.
Thank you, Your Honor. Careless, contaminated, culpable. My co-counsel, Savannah Patterson, came up here at the beginning of the trial and asked you to keep these 3 words in mind to describe the way that Peony Estates ran their winemaking operation. She asked you to think about how Peony Estates' carelessness led to the contamination of the Cara wine, which would make them culpable of negligence per se, leading to the death of Genesis Petrillo. Your Honor, Genesis Petrillo was a young woman with a long life ahead of her. She was about to get married to the love of her life, and she had a job opportunity set up for her in France. However, due to the careless acts of Peony Estates, which led to the contamination of the wine, she is no longer here with us today. Your Honor, the plaintiff understands that we have the burden of proof in today's case, a burden that we must prove with a preponderance of the evidence that Peony Estates violated Section 12-100 of Midland's Building Code. This Section 12-100 directly states that Peony Estates failed to train their employees and properly train their employees in the use of pesticides and properly store their pesticides, which eventually led to the death of Genesis Petrillo. We did this by calling 3 witnesses to the stand today. First, we called Casey Soto to the stand, the son of Harper Martini, who testified that Harper Martini moved the pesticide from the barn, which had a leak, into the storage area. Next, we called Riley Agnes O'Keefe to the stand, who testified that on multiple trips to Peony Estates, they found health code violations and that they saw the Cara wine on the shelf with the pesticide. Lastly, we called Lonnie Paris to the stand, who also showed you that the wine was sitting next to the pesticide, but also that same wine was presented to Genesis Petrillo on the day of the rehearsal dinner. Your Honor, the defense came forward at the beginning of the trial today and told you that they were the best in the business. However, through the statement of Casey Soto, we see that they're not only not the best in the business, but they also violated the Section 12-100 of the Midlands Building Codes. First, they brought forward Blair Osborne, the wedding planner for the wedding, who told you that Harper said, do not waste their time with training. Do not listen to that clown Agnes O'Keefe. Do not move the pesticide. Do not move the Cara wine. Next, they brought forward Danny Francazio, someone who said on multiple instances that he had never been to Peony Estates and that all he can testify to is to what Harper told him. And what Harper told him was that she was having trouble storing pesticides. Lastly, Your Honor, the defense called Austin Lewis to the stand. Austin Lewis, who said that they considered the use of pesticides like a nuclear waste. Whenever they're in the trash, it's like nuclear waste. However, Austin Lewis also testified to having put that same pesticide in the same room as the Cara wine that was presented to Genesis Petrillo. They also testified that Harper Martini forbade them from training their employees in the proper usage of pesticide. Your Honor, the facts are clear in today's case that on multiple occasions, Peony Estates not only did not train their employees properly, but they also did not store pesticide properly at Peony Estates. Your Honor, the carelessness of Peony Estates led to the contamination of the Cara wine, which is why Peony Estates is culpable in today's case. At the end of the trial, I ask you to find Peony Estates liable. Thank you. I'd like to save the rest of my time for rebuttal.
All right, we will do so, and thank you. And defense.
Your Honor, do you hear me all right?
I can hear you great. We proceed when ready.
Best in the business. What do you think when you hear those 4 words? Well, if you've been paying attention during the trial today, you might think of one thing in your mind: Peony Estates. Throughout the whole trial, our witnesses have showed why Peony is the best in the business. for their expert wine, their clean environments and safety protocols that they follow, but also the familial aspect of Peony Estates. Now, there's no denying something tragic happened. Genesis Petrillo sadly lost their life. And that's something that both the defense and the plaintiff can agree was a very bad and tragic event for the bride or husband, Casey Soto. But I'm here to just elaborate a bit more on what the plaintiff said. Careless, contaminated, and culpable. Now, Peony Estates, throughout its entire business, has been proven to be not careless. In Austin Lewis's own words, they followed the health and safety rules that they've established themselves. Austin has gone multiple times to teach the employees proper safety protocols, whether that be to spray off every area of the wine cellar that they had pesticides in, or just changing out of their clothes that they handled that pesticide in. That's a stark contrast from what the plaintiff said earlier, which was that Austin just hung up a bunch of signs that said, wash your hands. That is a clear difference right there. But one thing that struck me as surprising almost is that during this case, they try to find Peony Estates culpable, but Peony Estates isn't the one that's culpable here. It's Lonnie Paris. And here's why. If you listen throughout Lonnie Paris's entire, examination, Lonnie even states that they never notified the FDA about this supposed sample that shows that the wine was poisoned. Now, why would Lonnie do this? Judge, I just asked you this question today. What would Lonnie try and gain out of this? Well, here's what Lonnie will gain out of this. A rejuvenation in their career. As noted earlier, Lonnie's career just wasn't taking off around that time in 2018. So Lonnie set it out personally on herself to dig up a news story. Now, while Danny did give the tip about Peony Estates, it wasn't in any ill will. It was just simply a concerned business owner. And we've already established that earlier in the case that Danny's shown that, Harper has followed these safety regulations at Danny's own place. So to just assume that maybe Danny's trying to help Lonnie take down Peony Estates is just egregious at best. But if you paid attention to what Lonnie said earlier, when asked, well, is there any definitive reason that they can find that the sample came from your home or Peony Estates, and that there was no way to prove that fact? Lonnie responded yes. And I don't see why the plaintiff isn't bringing up this fact more. Lonnie admitted that there's no way to prove that the sample came from Peony Estates. And that's critical in today's trial because the whole point of the plaintiff's arguments is that they need to prove beyond a reasonable doubt that Peony Estates was liable for Genesis Petrillo's death. But if their own witness even admits that there's no way to prove that the sample came from Peony Estates, then we're just wasting time here today arguing the facts of the case when clearly there's no way to establish beyond reasonable doubt that Peony Estates was the cause of this. And this is critical because, like I said earlier, Peony Estates has a reputation. They're the best in the business. And while Lonnie was trying to look for a quick story, this has serious negative implications for Peony Estates as a business. But furthermore, it's just honestly sickening that Lonnie would use Genesis Petrillo's own death to advance her career. Now, that's something that's utterly culpable on the plaintiff's side. But I digress. Best in the business. What does that mean to us? That means we follow the rules, we have strong familial values, and we'll do whatever it takes to make sure that the customers have a proper, safe glass of wine. That's what Peony Estates throughout the whole entire trial has shown throughout our witnesses. Starting off with Austin Lewis. During Austin Lewis's words, Austin Lewis made sure that Peony Estates followed these own rules, even saying that they threw out over 20% of bad crops that had pesticide residue in them. Now, this is important because what business would willingly throw away 20% of their own crops? In my eyes, that just shows that this business truly cares about the well-being of its own customers. Now, while the plaintiffs like to come up here and say that, simply put, they just were careless and contaminated, quite frankly, I find that insulting on behalf of our defendants because we've repeatedly proven time and time throughout with Austin Lewis's testimony, Osborne's testimony, that Harper simply wouldn't allow something like this to happen at Peonia Estates. And I'll just backtrack to what was said earlier. Best in the business. That's what Peonia Estates stands for. Not carelessness, not contamination, and most certainly of all, not culpable. The real injustice here is the fact that Lonnie Paris could get away with this egregious error on her part in hiding evidence from the FDA by not even notifying them of this sample, but also that clear indication that there's no way to prove beyond a reasonable doubt that Peonia Estates was liable. And Lonnie even agreed to this when asked, is there any way to prove that the sample came from either your home or Peonia Estates? Lonnie answered yes. And I think that's more of enough impact to show the jury today that Peonia Estates simply cannot be proven without a reasonable doubt to be liable in the tragic death of Genesis Petrillo. Thank you, Your Honor. I ask that you find my defendant or the defendant's Peonia Estates not liable for the death of Genesis Petrillo.
All right, thank you. Rebuttal?
Yes, Your Honor. Best in the business, Peonia Estates was the best at pushing the blame. Your Honor, Peonia Estates just came up here today and said that because Lonnie Paris didn't tell the FDA where she got the pesticides from, she is responsible for the death of Genesis Petrillo. However, Your Honor, that's not true. Lonnie Paris has no legal responsibility to tell the FDA where she got that sample from, but Peonia Estates does have the legal responsibility to tell the FDA, to follow the FDA's guidelines. Your Honor, Austin Lewis came up here today and told you that Peonia Estates used chemical pesticides. That is an undisputed fact in today's case. You know what Austin Lewis also came up here and said? He also came up here and told you that he was forbidden from training Peonia Estates' employees, and Blair Osborne corroborated that testimony where she heard Harper Martini state, do not waste the employees' time with more training. Your Honor, the burden of proof in today's case is not beyond a reasonable doubt. It's with preponderance of the evidence that 50% plus the tip of the scale that Peonia Estates was indeed liable for negligence per se in today's case. Based off all of the evidence that we brought you today, we have showed you that Peonia Estates was careless by not properly taking care of wine storage, which led to the contamination of their wine, which was then testified to have been brought directly to Genesis Petrillo, and therefore are culpable for negligence per se in today's case. Your Honor, I ask that you find the defendant liable of negligence per se. Thank you.
Thank you. All right, we are done. Good job, everybody. So what we're going to do while Mr. Hill and I fill out our ballots, could I have all of the participants please turn their camera on so we can see everyone as we do our rankings and stuff? Okay, thank you all, and I will get back to you whenever we're done. Thank you. Okay, I believe I'm submitted, and then I believe, Mr. Hill, you're submitted as well.
Yeah.
Perfect. Well, I'm gonna you've heard a lot from me, so we'll do brief comments. I know it's been a long day, so Luke, I'll let you go first.
All right. Hello, everybody. My name's Luke. I'm the scoring judge, the one you haven't seen the entire round. Phantom jury, some might call us. Good job, everybody, for completing the third round. I'm just going to give some general overhead comments. I know we've all had a long day and are probably looking forward to thinking about anything other than mock trial. So overall, I thought the trial went pretty well. Some big things with objections. I don't know, obviously, whatever we say, take with a grain of salt, and whatever your coaches say, go with that, because that's, generally how this kind of stuff works. But with objections, I've never been taught to withdraw them, even if I think that I'm losing, or if I know that I'm losing, and I'm like, man, shoot, I'm completely stumped. Usually it's, my coach always taught me to, die on that hill if I have to. Chris and I both did mock trial in undergrad actually together. I guess I should have said that. I'm a mock kid too. I went to Baylor undergrad, Baylor Law School. Right now I'm a 2L. So I'm pretty familiar with this scene and kind of how all this rolls. And so I know how much work everybody put into this. So that's great, especially with it being online. It's nuts. But yeah, objections, I would not back down. I wouldn't withdraw an objection really ever. I can't think of a situation where I would, but if that's something that y'all are being taught and is specific to wherever you live, obviously that's, a different story. On cross-examination, if you want a witness to answer with yes or no, ask them questions that make them answer with yes or no. It's not enough to just say that you're going to have to answer yes or no, even if you try to frame it in the context of we don't have a lot of time, so you're just going to have to play by my rules. I hate to break it to you attorneys, that's not how it works. Obviously, cross is the time for your show, but you don't get to make the rules for your show. That's up to the judges, and we get to decide that kind of stuff. And if you ask the witness a really long question, or you ask them a question that can be answered with something other than yes or no, you can't get upset and then complain to the witness. I mean, obviously, if a witness is being combative and they're not answering the question, that's an entirely separate issue. And then you can try to bring them in. We were always taught to use 3 steps. The first one is kind of blame yourself. Be like, maybe you didn't understand me. Maybe I wasn't clear with the question. And if there's still, being combative, maybe I just need to completely rephrase the question. And if they're still, going off, then maybe even go to the judge. Your Honor, at this point, the witness is being non-responsive. If you could please instruct them to answer the question. And then the judge can get mad at them. And that's nice because then we get to rank them even lower. Sometimes for being combative. So that's great. I thought overall there was good eye contact, which was really important, especially in the virtual setting. There were a couple of instances where I don't feel like there were a lot of notes reading in this round, which I appreciate. Some of my past rounds I've done, there's been pretty obvious, but either y'all are really good and fooled me, or I just didn't notice. So good work on that, everybody. But just remember to, especially if you're crossing a witness, to actually look into the camera instead of looking at the witness that you're crossing. At least for me, kind of the jury, it felt like a lot of the conversation was between attorneys and witnesses. And on that note as well, specifically on close, remember who you're talking to if you're talking to the judge or the jury. I think there were a couple of instances where it got a little confusing. And then my last big criticism is to respond to what's going on in the courtroom. If a judge is making a certain ruling on character evidence and he keeps asking for a specific thing like a character trait, pick up on that on future objections, even if it's opposing counsel, and kind of try to implement that and try to really be adaptive. And that's really, I think, what sets teams apart from good to great teams, are the teams that kind of adapt and do that kind of thing in the courtroom, and they kind of go off script and are able to implement what's going on. But other than that, that's kind of my general stuff for y'all. Again, great job. I'll let Chris kind of give some of his comments now.
Yeah. Well, hi, everybody. For those of you who don't know, my name is Christopher Royce. I'm also a 2L at Baylor Law. Kind of like Luke said, we competed together at Baylor. Good job. You all did great. I just want to make that clear. My notes that I just submitted for you all, it has a lot of negative things because I don't think it's really helpful for me to tell you what you did well. So individual comments are going to be there, but I do want to address a couple of quick things. Going off what Luke said last, I want to elaborate a little bit more on that. And I think when it comes to objections, attorneys, you need to not only respond, you need to respond to the objection that was made. So if they're talking about a hearsay objection, I don't need to be knowing the purposes of why you're using it if it's not one of the relevant ones for hearsay. Additionally, use the hot language that's in each one of the rules, right? 404, you're not using this character trait for propensity, for conformity therewith. Hearsay, it's an out-of-court statement being used for the truth of the matter asserted, right? Use those terms and make sure that you're not only using them, but you're applying the facts of what you're objecting to in that. So if you're objecting to hearsay, tell me what specific statement you're objecting to. If you're objecting to 404, tell me why they're using this testimony and what character trait it is. And then on the response end of grounds, well, no, Your Honor, we're not using that for purpose, but that's not enough. You need to tell me what you are using it for then, right? There was a lot of relevance objections in this round. I hate relevance objections because I think the standard for them are so low. But most of the time when I'd ask for responses, I wasn't getting why it was relevant, right? You need to tell me why it's relevant, why it makes a fact in this case more or less likely, okay? So just make sure to respond to those objections and make sure you're using those standards and applying the facts to that standard. Additionally, with that, witnesses on the other hand, I thought this was a really strange round for witnesses in terms of, I thought all of you, most of you, not all of you, but I think most of you were one way on direct and another way on cross. And I know there's kind of like this rule or this premise out there that, well, I have to be nice and likable on direct, and then I have to be aggressive to make sure that they don't get what they want on cross. That's not how it's supposed to be, because then I don't believe you and your credibility is gone. So if you're playing a nice, likable witness on direct, you need to make sure to keep that up on cross, okay? And kind of vice versa with that. I think you need to talk more on direct and talk less on cross. And I think there was some of you that really wanted to talk on cross, but direct, there was kind of the show was focused on the attorney, and that's not the case. And so, attorney gets points, good, but then you as a witness loses points. So attorney witness pairs, y'all have to work together to make sure y'all get that good balance. And then I guess the final note that I have is just, I'm pretty tough on cross in general. What Luke said about how to go about controlling your witness, that's really, really important. That's a skill that is not easy to learn. I probably still don't know it, and I did this for 4 years. So I understand why it's difficult. Attorneys and witnesses, I know it's difficult to find that line of where's am I arguing too much and not fighting enough. But I think that one thing you need to do is prepare for the next tournament is really just cross. Get ready for every possible type of witness, because I think I saw most of the time, I could see on your faces, attorneys, when you were affected by the witness not giving you the answer you want. Sometimes that happened by you talking too fast. Witnesses as well, I think some of you, I could see you're not liking what they're asking on cross. But if you're a disinterested party, why does that matter to you, right? Sure, you're not getting the points, but you're playing a witness. So just remember those roles and remember what you're doing. And I promise you the scores will then improve because of that. So overall, just really good job, guys. It's round 3. I know y'all want to have plenty of time to get ready for round 4. But that's all that I have for you. If you have any questions for Luke and I, we'll stay on for a minute. But if not, best of luck to you all. Oh, what schools are you from?
We are from OU.
Oh, okay, cool. Nice.
From the University of Houston.
Nice. Awesome. Well, very good job, both of y'all. And best of luck in the final round. And we'll stay on if you have any questions.
We did have a quick question.
Yeah.
We've noticed that a lot of judges want us to have our screens on during the opposing, if I'm the crossing attorney, during my direct that I'm handling. And normally when we're in person and I'm like taking notes for a cross, maybe adapting my cross to what they're saying, it's no big deal. But we noticed that on Zoom, you can only see this part. And so it just looks like we're looking down. Is that something that you guys noticed, or do you have a way that we can still be professional and we just don't want you to think you're like looking at your phones or something, Yeah,
no, I think that's a hard, Zoom type of only thing. I personally, if you're taking notes, if someone's crossing and you're taking notes, I'm okay with that. Looking down, like I mean, my thing is, if they're getting away with testimony, you're not objecting, that's on you. That's not on them. I'm not going to be paying attention to you as much during that. I think it really is just to help I don't want to interrupt or like turn my screen on and unmute every time I want to object. So that's my personal opinion. However, I do understand the whole like reading thing because I know people hate reading. I hate reading. So the best way, honestly, I would try to would work with that. And we had this in another competition, but if you have like a table or something like that, like angle it in a way to where like they can almost like see like your pen or something, like they can see that you're actually writing. I know it sucks and it's not ideal at all, but if you're getting complaints, that's a way that I would try to tackle it. Luke,
We haven't yet. We were just concerned about unprofessionalism and just wanted to get
that's
ahead of
fair.
that.
Yeah.
I never saw anything that made me think, oh my God, she's on her phone playing, I don't know, whatever.
Perfect. Thank you guys so much for judging.
Yeah.
No problem.
Wonderful time.
Thanks.
I actually did have a quick question. Sorry, I know I'm just timekeeper, but I am my team's team captain, and it was something that came up during the round. It was that, do you have the exhibit in front of you? I did it based off of like, I know we didn't say this during pre-trial, but what I told my team was to constructively share it outside of the view of the jury and authenticate it that way, and that they didn't necessarily have to have the exhibit in front of them, because that's what I saw from one last time tournament from last year's competing seniors. Is that okay, or is there a rule against that?
There's not necessarily a rule against that, but I explicitly said in pre-trial that that's how I wanted the exhibits treated. In fact, by that time that it had come up, it had already come up twice beforehand, and I made sure to remind. So defense wasn't the first team to mess it up, don't worry, plaintiff messed that up as well at the beginning of trial. But you have to be able to, again, what Luke said, you have to be able to adjust to what the judge said. The way that I'm doing it, I've seen more competitions do that. This is my third competition judging this year, and I think all but one round I've seen have done it like that. So just you be able to adjust to whatever the judge says, because like I said, I did explicitly say in pretrial. So yeah.
Oh, okay. My apologies.
No, it's all good. Again, I understand I know it's hard when the judge throws you off of something that you've practiced, but just that's like in person as well, right? You got to be able to adjust to what they do. And most likely, I mean, I don't think I end up docking anybody for it, but I made notes of it in the individual comments. Like, you got to watch for this, because while I don't hold it against you, there are judges that will very much hold that against you.
Absolutely. Thank you so much.
No problem.
Thank you, judges.
Thank y'all.